I beg lordship pardon, my lord. Item, I am mentioning for item 51, my lord. I have talked to the other side. I have informed the other side, my lord.
51 file. How is this matter listed before this court?
I don't know, my lord.
This is not the bench assigned to this court today. I am only taking up bench 2 and 3. This is a bench 4 matter. I've not kept it parted also.
And only I will take 15 minutes, my lord.
But I can't take it because this is not a matter assigned to me. Because there is no order. This is a bench 4 matter.
The other side is here, my lord.
Sir, this matter is not assigned to me by the Chief Justice. How can I take it up? This has come wrongly.
From Calcutta, my lord, I have come.
Calcutta, you may have that practice. We don't have that practice, unfortunately.
No. Now,
If you want it, I'll ask the registry to list it before the court today itself. No problem. 2 o'clock, you can have it.
before your lordship.
No. Before the competent bench, which is taking up the matter. The present matter pertains to bench 4. Further, the matter is not tied up and or parted by this court. So, accordingly, the registry to list this matter before the appropriate bench. The learned counsel for the petitioner has submitted that there is an urgency in the matter and he is an outstation lawyer. And accordingly, submits that the matter be taken up before the appropriate bench. So, the matter be taken up today. Registry is required to look into the matter and to list the matter before the appropriate bench, if possible, today. Please,
Lord. I'm
The registry, ask your local counsel to meet the registrar, local registrar, he'll do the. I'll send the file down only. Yes.
I'm praying for an adjournment in item number 13, Lordship. We have already circulated an adjournment slip as well, Lordship.
No? Or you circulated?
Yes, Lord.
Why? What is the reason?
Lordship, Counsel Mr. A. Sharma is out of station today,
A
Lordship.
prayer is made on behalf of Mr. A. Sharma, learned counsel for the petitioner, for an adjournment in the matter on account of personal. So prayer is not objected to by the learned counsel for the respondents. This is a motion matter.
Yes, Lord.
We can't do anything today. We'll have to issue a notice only.
Lordship, there is an interim prayer, Lordship, regarding the release of the retirement
That
benefit.
we will make it returnable, let it come back. We'll see.
Can it be taken up on 17th, Lordship?
Registry to list this matter again on 17th or board is it again? 17/6/2026.
I'll leave that.
Wait, please, Your Lordship. Lordship, I beg to mention item number 19, Your Lordship. Lordship, I've taken the consent of the other side, Your Lordship. Lordship, there is some personal difficulty, Your Lordship, today, Your Lordship.
On
Great.
Mr. PJ Soikia's part. Prayer is made on behalf of Mr. PJ Soikia, the senior counsel, for an adjournment in the matter on the person inconvenience. Prayer is made with the consent of the learned counsel for the respondents. Accordingly, registry to list this matter again after 3 weeks.
Yes,
On
sir.
huh?
May I pray for a fixed date, Your Lordship, after the.
on 17/7/2026. Yes, madam.
My lord, I'm sorry, my lord. Item 15, I forgot to bring the file. Or if your lordship issue notice, then 15 is.
1515. Nalage gunna. Is the word.
May I please, Your Lordship? I beg to mention item number 24. Your Lordship? 25.
Why?
The youngest counsel of this case out of station, Your Lordship. Kindly adjourn the matter only for the judge.
M.H. Ahmed.
MHM.
Prayer. Ahmed. Have you informed the other side?
No, I think
What is this? Very well. Inform, make the mention when it reaches.
item 25.
So Lordship, with regard to item number 29, Senior Counsel PJ Sakya sir is having some personal difficulties.
Okay, I'm going to. Have you informed the other side?
Yes, Lordship. Yes, Lordship.
Okay.
Date may be fixed, Lordship. Can it be,
Huh?
can it be on 25 or 26?
After the vacation. 20th.
Obliged, Lordship.
Item 12.
Right, please, your lordship.
We will consider. We'll issue a notice now.
Well.
But Mr. A. Borua, Learned Counsel for the petition. You have not got the orders still on record, the promotion orders,
No,
the petition.
the petitioners are there, but the promotional orders are the.
The petitioner in the present writ petition by projecting that he is senior in the cadre of junior assistant to.
Three petitioners are there, lordship.
Writ petitioners are seniors to the private to the respondents number 4 to 10 in the cadre of junior assistant in the district of Sipsagar, have instituted the present writ petition. Essentially, the promotions effected in respect of the respondents number 4 to 9 to the cadre of senior assistant, ignoring the cases of the petitions hearing.
4 to 10, lordship.
4 to 10. Also, the petitioners submit that in terms of the provisions of Rule 6 of the Assam, secondary education bracket provincialized schools bracket over service rules, 2018, they are eligible for being considered. They were eligible for being considered for promotion to the post of senior assistant on the date when such consideration was extended to the respondent number 4 and 10. Also, issue notice, returnable 4 weeks. Mr. B. Kaushik, Learned Standing Counsel, Department of School Education, accepts notice on behalf of respondent 1, 2, 3. No formal notice. Petitioner to take steps for service of upon the respondent number 4 to 10 by way of speed post steps within 3 working days from today. Registry to list this matter again after 4 weeks on a date to be fixed by it.
Lordship, may I pray that in the interim, if anything may not be about.
It's long back.
Long.
Lordship. Obliged, lordship.
May I please, Lord?
Ms. Das, you have not made the AG a party here.
Yes, no, Lordship.
The salary will be given finally by the AG. Okay. Which is the period you are claiming now?
Lordship, here page number 24, annexure 7, there is one forwarding letter. Letter has been forwarded by District Elementary Education Officer to the Director. The amount is given, Lordship.
Okay. This is. You come to page 15. Have you got the suspension, remaining balance of the suspension amount, remaining areas of the suspension period? Page 15. Have you got this amount? Your suspension has been treated to be on duty.
Yes.
But if you come to page 24, I don't find this period to be included here.
In this page, that period is not.
Then
included.
where is, because you have only prayed for 187 in your prayer.
For this period, Lordship.
Suspension? You have got.
That he have got.
Heard Ms. A. Das, Learned Counsel for the petitioner. Also heard Ms. Learned Standing Counsel, Secondary,
Elementary, Lordship.
Elementary Education Department. The petitioner in the present writ petition has prayed for a direction upon the respondent authorities to release to her the arrears of pay receivable by her for different periods amounting to rupees 1,87,313. The petitioner contends that the said amount on being verified, was in form of a proposal forwarded to the Director of Elementary Education, Assam Kahilipara, by the District Elementary Education Officer, Dhemaji, by a communication dated 29/7/2024. However, further processing in the matter thereafter has not taken place. She submits that the checklist as mandated was also included in the proposal as forwarded by the jurisdictional DEEO. Also, issue notice returnable. Or we can dispose it off. Or you want a notice? Notice is better. Notice returnable 4 weeks. Ms. Swanso accepts notice on behalf of all the respondents. No formal registry to list this matter again after 4 weeks on the queue.
Obvious, Lordship.
Only thing that period, whether the contractual period can be taken into consideration.
Yes, my lord.
Heard Ms. K. Devi, Learned Counsel for the petitioner. Also heard Ms. G. Shraddha, Learned. Standing Counsel,
S. Sutia, my lord.
huh?
S. Sutia.
S. Sutia. Shraddha Godish.
Standing Counsel Elementary Education.
Elementary Education Department, appearing for the Secondary Education Department, and Miss
N. Hazarika.
N. Hazarika, appearing on behalf of Mr. P. Naik, Standing Counsel, Assam Sarva Shiksha Abhiyan Mission. Also, and Mr. P. Soikia, Learned, Government Advocate. Also, the petitioner in the present writ petition has prayed for a direction upon the respondent authorities for release of the pension, the retirement, the pension and pensionary benefits, including the NPS accumulated corpus in pursuance to the death of his wife in harness. Also, issue notice returnable 4 weeks. Ms. S. Chutia accepts notice on behalf of respondent number 1, 2, 3,
to 5,
4,
madam.
5. Ms.
6, 7.
Endas accepts notice on behalf of respondent number
6 and 7.
6 and 7, while Mr. P. Soikia, Government Advocate, accepts notice on behalf of respondent number 8 and 9. Returnable for Baki, no formal notice. Huh?
Obliged, your lordship.
There is no representation on the behalf of the respondents. You have 50%.
53% actually, but they have said according to last circular issued by the principal, there is another 25%, page 63. And already 400 classes should be held, only 163 classes has been held. The petitioner is supporting various ailments.
You will be NC means non-collegiate.
DC means discollegiate.
Discollegiate. You will not. You are now presently discollegiate because of the. You have submitted your form.
Lordship.
But Mr. S.K. Goswami, Learned Counsel for the petition. Also, the petitioner in the present writ petition has projected that he is presently pursuing his undergraduate program in engineering in the Assam Engineering College, pursuing his 4-year undergraduate program in engineering in Assam Engineering College, and is presently pursuing his such course in the 4th semester. The petitioner projects that he has already cleared the first and second semester and has also appeared in the examination for the third semester. The fourth semester examination is now scheduled to be so conducted with effect from 19/6/2026.
17/6.
It's 19 here, page 61.
Nineteen-six.
19/6, so at 2026. And the petitioner had 17, but in your prayer you write 17. How? Which is correct?
As per my information given by the client, it is fixed 17.
17/6/2026. The petitioner, in pursuance to the notice issued in the matter, has already submitted his form for appearing in the said examination. However, in pursuance to a notice dated 9/6/2026, requiring the candidates appearing in the fourth sem regular examination to download their admit card by logging into the website of the Assam Science and Technology University, the petitioner was not in a position to download his admit card. On inquiry, the petitioner was given to understand that as he did not have the requisite admission, had he had not taken, had he had not appeared, as he did not have the requisite attendance, the petitioner was treated to be a discollegiate candidate. It is projected that the college authorities, that the principal of the Assam Engineering College, in view of the number of classes held during the fourth semester, had relaxed the attendance criteria for non-collegiate category candidates to 55%. The petitioner projects that he has 53% attendance. Also, the reason
may record above 50%.
Above 50% attendance. The reason for not having full attendance has been projected to be on account of the ailments suffered by the petitioner during the fourth semester period of study undertaken by him. The petitioner, in support of his such claim, has brought on record the medical records, including the reports received from various labs pertaining to the ailments suffered by him. Suffered by him. The petitioner further projects that for the medical ailments supported by medical ailments which are supported by medical documents submitted to the college authorities, a further 25% reduction, 25% relaxation in the attendance criteria is mandated. However, the petitioner projects that the same was not considered in his case, and accordingly he was declared to be a discollegiate, and accordingly he was held to be a discollegiate candidate, and he would now be not permitted to appear in the ensuing fourth semester regular examinations, which is contended to start from 17/6/2026. Issue notice returnable 4 weeks. Petitioner to take steps for service of notice upon all the respondents by way of speed post, as well as by way of dusty mode routed through the registry of this court. Steps within 3 working days from today. Also, in the event the steps are in the event service of notice is so affected upon the respondents by way of dusty mode, petitioner to file an affidavit after effecting such service. Also, in view of the projections made in the present petition And considering the fact that the petitioner has already cleared his first and second semester examinations and also appeared in the third semester examination, comma, pending a final consideration of the reasons assigned for not having full attendance as mandated, comma, balancing the equities, this court directs the respondents number 1, 2, and 3 to permit the petitioner to appear in his fourth semester examinations, which is scheduled with effect from 17/6/2006 and or any other date as may be fixed by the, as may have been fixed by the university authorities. The petitioner shall produce a certified copy of this order before the respondent number 1, 2, and 3 on 15. Today, tomorrow is holiday.
Holiday.
15.
Today itself I can close it if possible.
Okay. I shall produce a copy of this order before the respondent number 1, 2, and 3, who shall thereafter take all requisite steps to facilitate the appearance of the petitioner in the ensuing fourth semester examinations as fourth semester examination in the undergraduate program in engineering from the Assam Engineering College in the
Computer science.
fourth semester underlying, which is being presently pursued by him. Also, it is further provided that the results of the petitioner shall not be declared without leave of this court. Also, registry to list this matter again after 4 weeks on a date to be so fixed by it. It is remains by my idea. Mungia did little. Mr. Bhattakur, what are you waiting for? Which one?
You kill euros.
Huh?
Item number 8 euros.
228.
Not 228 euros, only 8 euros.
Oh, that.
Lots.
PDC.
Lots.
We'll just finish up
Lots.
228.
Lots.
So-
Dip.
Mr. Ahmed, all are Sipsaga,
Allah Sipsagar
and this is the first round of litigation by them.
that's it. And except the name and addresses and all.
Issues are same.
same. All are same.
This is the first round of litigation by them before this court.
That's it.
Before this, they have not appeared. They have not instituted any writ petition before this court. Prior to similarly situated persons have come. You have prayed that those orders are covering your case also.
That's it.
Now, you have all been either accommodated as teacher and tutor or tutor.
Not all, but a few left, my left.
Few left.
Few, I'm not-
You have not been found. You all appeared in the select screening committee before the screening committee.
Not such type of procedure, my lord. It is like a dotted line contract, my lord.
No, forget it.
just-
There was an advertisement. Did you appear before the screening committee
There-
thereafter?
there-
Otherwise, the persons would not have been selected. So you have appeared before the screening committee. Did you take a leave from this court before? Because the matter was pending at that point of time. Did you take a leave from this court?
No, my lord. I didn't.
Okay, now you can proceed.
But before that, my lord, one of the conditions of the new undertaking an appointment letter is, my lord, one person, petitioner, the candidate must be.
Mr. Ahmed, you also know, I also know
Lordship,
what happened in
Lordship.
Tipsagar.
Lordship.
Okay.
Lordship. That is,
And the allegation against you is that you are excess teachers.
yes, Lordship. Not illegal and irregular, my lord.
Fine.
And my lord, Lordship is very much.
Excess is also illegal and irregular.
What are the making access? It was the proper measure was taken or not? That has to be looked into, my lord.
So now,
Because
first,
My
show me
grievance
that your this initial appointment was,
My lord, kindly, my lord, because my lord, all the six, my lord, same documents, except date and address, my lord. If you lordship peruse one set of documents, my lord, it will cover
we'll
all.
only take up 7914/2017.
7914, my lord.
First case.
First case, my lord. That all are same, except the name and addresses, my lord. Grievances same, my lord. Few didn't take any appointment or the giving any.
Dates of appointment would be different.
My lord. Dates of the different, my lord. That is, my lord.
The authorities appointing are practically the same.
My lord.
F. Karim or Mr. A. Hussain.
My lord. Page 51, my lord. 51 of the application, my lord. This is the appointment letter, my lord. Ras Kumar Shah, my lord. Then, my lord, page 90, lordship. That is, my lord, training completed, my lord. Training completed. Then, my lord, 116, lordship. It is a regular scale of pay has been given, my lord. With efficiency bar among, my lord.
Earlier one was completion is 93.
90, my lord. My lord, what has happened, my lord? Stay incident has been blown out of the proportion and given wide publicity that illegal, my lord. That all the teacher cannot be paid with same brush, my lord. It's each and everyone has individual documents, individual appointment later, my lord, and they fail to show, my lord, how we are illegal, my lord. There is no in RTA reply, my lord, there is no mechanism, no measuring stick to identify illegal and irregular. That is that was
We consider you as irregular. Now show me the advertisement, number of posts advertised, select list, your position in the select list.
Select list, lordship, select list. Select list, I don't have those.
How do we?
Select list.
You were.
Those.
Okay, you have brought on record the advertisement.
Those who are regularly walking, my lord.
Regularly working has to be with the.
They have the same.
Mr. Ahmed, we are now having the benefit of hindsight. We can look from today.
Lordship.
The category of teachers that you belong to.
Lordship.
For them, there were directions from this court requiring the state to take a policy decision. The state took a policy decision.
Lordship.
Placed it before the cabinet.
Lordship.
The cabinet then said, then the cabinet gave a go ahead. Then they proposed a screening. Screening was proposed 3 categories. 1, 2, 3. 1, both 2006 pay as well as JBT teacher. Category 2, tutor. Category 3, what happened?
Category 3 is those who are not
They were not appointed.
Not appointed.
So you then got an appointment order, wherein there is a stipulation that it will be effective, say, from 1/11/2020, with further stipulation that you can't claim any back wages.
That is, we have to withdraw the content or WPC. I have to withdraw. You cannot claim the all benefits of past service, which is pending, my lord. We have to withdraw. That is one of the conditions, my lord.
You will have to withdraw and make a challenge to that.
My lord.
Because if that is there and you have accepted that on your own free will,
Lordship.
And you are continuing,
that is,
now,
my lord.
How can you
Lordship is absolutely right, my lord. Whether the petitioner has accepted willingly or it was forced, violating the article.
Where is the material?
I have a material, my lord. Show me. I have a material, my lord.
Have you challenged that?
My lord, I have made amendments, my lord. Not
so you don't want that. You don't want that.
Lordship, I have challenged, my lord.
Where?
I have challenged, my lord. Before that, my lord, I have filed representation of this 2%. P62. Volume 4.
Where is your material?
Let's see, let us place T62.
360.
Whether the petitioner were happily accepted the
Oh, happily,
or
not
it was
happily.
forced.
Where is the challenge? 362.
T60, T62, my lord. T62, my lord. That is when the advertisement made, my lord. Since we are not illegal. That apart, my lord.
Okay, accepted. Now show you establish.
Lordship.
Got it. Now you establish that you were appointed within the strength of the advertised post. That's all. Or show me that the government had permitted for extension of the number of posts advertised or increase of the number of posts advertised. We'll not go into anything else.
No, my lordship, I want to establish that whether we are willingly or we are forced, my lord. Because, my lord,
Forget it.
my lord.
That thing we are interfering. We'll interfere with that.
That
No
was forced, my
problem.
lord.
But now you establish that you are entitled to an appointment in law.
My lord, for that, my lord, how we became the group of 1528. All the cases pending in the courts, my lord, belongs to 1528. How and why it was created 1528, that is most important. I was victim because I was appointed post August 95. That is my grievances, my lord. Even my lord, screening committee report, my lord. Properly selected, everything, my lord. So far, report of the screening committee, my lord, by exercising the article
That's
1.
not under challenge before me, so I'll not go into that.
My lord, I have a categorical affirmance, my lord.
Categorical affirmance will not do.
Separately, I have
That is
challenge.
something which came. We will ignore it. We will say that either we will say that you are entitled to your salaries from the date of your initial appointment continuously, or we will say that the subsequent regularization is not accepted, so we set aside. Then examining the materials you place before us, we find that your appointment is in terms of the rules holding the field, or if we find that it is not in terms of the rules holding the field, we'll interfere with that. That's all. We can't have any other view. Either yes or no. We can't be in middle.
Lordship, similar situation handled by the Honorable Apex Court, my lord, and Lordship Korean bench also, my lord. My lord, if you lordship, allow the report of the screening committee.
The screening committee is bogus.
My lord.
It's gone.
Under
we assure you we will set it aside.
They are.
But now you establish your right to your appointment as stipendary teacher.
Lordship. So for appointment later,
Mr. Ahmed, you also are aware that if the appointment is not in terms of the rules, whatever consequential benefits you claim will not be there. Then it will be only grace. It will be only grace. This court can, in exercise of its power under Article 226, considering the long period of service, may come to your assistance by directing them to consider your payment of salaries. But that will also be with the hedging that your services should be terminated.
So far, my lord, I annex as a covered case, my lord. That has been not reviewed or appealed, my lord, attend finality.
That is in the facts of that case. Now you show me the facts of your case.
Same facts, my lord. Same facts. Dicto, my lord. Accept the name, my lord. Same facts, my lord. Same facts.
What is the status of those employees, petitioners? What is the status of those petitioners?
Contempt proceeding is pending.
That has not been implemented till now.
My lord,
they may also have come under this screening.
Not implemented, my lord, because, my lord, kindly, my lord, why this new appointment is 369, lordship? Why this all-cure formula they invented, my lord? This 369. 369. May I read, Lordship?
That is, we got it. We got it. This is not in your case. There is no order covering you in this case. And that
No,
is,
my lord, that is regarding 1528, my lord. We are all the teachers, whatever the case is pending in our High Court, my lord, all because belongs to 1528, Sibsagar district.
okay, got it.
Hello.
Then next submission.
In order that perhaps it will be not be possible to comply with the High Court order, my lord.
Okay.
That's to save from the contempt proceeding, my lord. After 10 years, my lord, after 10 years, they introduced this formula, my lord, and added this caveat, my lord. Somehow, my lord,
You
lord.
also accept that in your case, salary was released after creation of supernumerary post.
Yes, my lord. So,
That itself shows that you were not appointed against the regular sanction vehicle.
my lord, since my lord, so far creation of post is a dictation of the policy decision, my lord, for exigency of circumstances or administrative need, my lord. So since we are, I'm admitting, my lord, since we are in a created post, my lord, how can we have illegal and irregular, my lord? This created the GOP itself, that policy is not cancelled, my lord. My earlier appointment letter not cancelled, my lord. On the basis of that, Honorable Justice, we are passed the order, my lord. That was not challenged, attend finality. So
And
far,
that order till date is not complied with.
my lord, that is.
And there are subsequent orders of this court how to deal with illegal and irregular teachers. That has now culminated in this teacher-tutor appointment.
Not see, till date, they have failed to show what is the terms and condition to be illegal and irregular, my lord. No way, my lord. Even
That
RTI
we,
reply,
Mr.
my lord.
Ahmed, we will deal it with our limited knowledge. What is
Lord,
illegal? What is
I have limited knowledge, my lord. Let's see, my lord.
We'll.
Just trying to.
You show me two things that you were within the merit position against the advertised post, which you can't show.
Merit position, merit list, that list was, I don't have, madam, but.
There was no list.
My lord, kindly come to Lordship. Kindly come to page 309, madam. 309 and 310, Lord. My lord, some of the petitioner, my lord, approached the authority directly, my lord, some before your lordship. Who approached the authority, my lord, from 1528, my lord? This is my lord. In enclosing here, the government.
One illegality, we are not going to perpetuate that. Negative equality is not, no equality.
No, my lord, we are from the same category, my lord. Same category, same 1528, my lord. You are also request, my lord. I have the honor to request you kindly to release monthly salary to Sri Gopal Kolite so and so. You are also requested to inquire into the matters as to how and for whose fault the name of the teacher has been enlisted among 1528 excess teachers. So we are not an excess teachers, my lord. That was.
But your whole thing, the earlier petition and all are 1528, you say you are within 1528. Now, if it is within 1528, that is excess. You can't change your stand.
My lord, no,
Whole
lordship.
pleading is in that direction.
My lord, they have made us 1528, my lord. We are not an excess, my lord. Because, my lord.
Then that is why you show me the merit list. If you are claiming that, show me the merit list. Or the advertisement. Where is the advertisement?
Lordship, advertisement, so far 1528 is concerned, my lord. The figure of total working teacher in Sibsagar district was during the 91 and 2000 was found 7737. And in the year 2003 and 4, it was detected that the working teachers number more than the budget allotted post. Which
You're
figure?
reading page?
609. That is, my lord. Sorry. 304, lordship. In second paragraph, that said, while rotational process was stopped of the salary of all LP school and teachers on Sibsagar district could not be paid. Therefore, the matter was informed to the Director of Elementary Education, Assam Academic, then Director of Education, Assam had directed the respective DDOs of the district to release monthly salary on seniority basis of their appointment letter, appointed order. In this connection, DEO Sipsagar via his office letter number so and so have directed the DDO of the district to release monthly salary on seniority of appointment order so and so. So DEO Nazira along with the other DDOs of the district have released the monthly salary of LP school teachers on seniority of the appointment. In releasing a salary on seniority basis, the budget allotted posts have covered up to the teachers who were appointed up to August 95 and teachers who were appointed after August 95. We are after 95, that is our fault, my lord, as per them. Who were appointed after 95 have been left out and therefore monthly salary. Depart from monthly salary. The petitioner OBB teachers so and so, madam. It is, my lord.
Depart from monthly salary from which month?
Month. August, we receive up to salary 2012, let's see. 2012 received the salary, madam.
March 2012.
Up to 2000.
February 2000.
February.
So up to, lastly, we received releasing salary on the seniority basis was done in 2007, my lord. As supernumerary was created in 2009, my lord. Payment of
2007, you were getting salary. Thereafter, this
up to
rotation
2000
and till 2012 by supernumerary.
supernumerary. So this categorized also, my lord, only because of disbursing of salaries, my lord. No irregularity and illegality, my lord. Even the RTI reply, they said there is no mechanism to identify irregular, illegal, my lord. So we cannot be banded as a illegal and illegal, my lord.
That's why we will require some basis as a or court of records will require some basis of your appointment. That's all.
Only because of, my lord, I was appointed post August 95, my lord.
That is too
My lord.
feeble a plea.
Then, my lord, page 308. Page 308, let's sir. Our posts are occupied by these are the teachers, my lord. Required,
Made them party respondents.
lordship, page 308. So, required age was, my lord, 18 years, my lord. All these minors, 17 years, 9 months, 17 years, 10 months, 17 years, 7 months.
Ahmed,
16 years.
Ahmed,
My lord,
two options to you.
my lord.
We will go and decide the matter finally and hold that whatever you have got in that with effect from 1/2/2020, considering the background is perfect, no further interference. Or you withdraw these writ petitions, we give you liberty to challenge the subsequent accommodation.
Subsequent accommodation, I have made category.
There is no challenge. That will be of no consequence because it will happen here in between. That is why I said my first option is we will take into consideration that because it happened in the course of this consideration of this writ petition. And we will take that into consideration and come to our conclusions. For your betterment, you withdraw this because of the subsequent development, challenge that properly.
Subsequent development, that is, my lord, subsequent development, my lord, I have categorically made aberments challenging those, my lord. And same situation will deal with.
Just give me those aberments.
My lord, may not be the challenge word, my lord. All aberments made in my.
Mr. Ahmed is too a seasoned lawyer to understand that concept. Page. Where have you made the aberments?
Inequality bargaining power. And similar situation dealt by Honorable Apex Court and lots of coordinated bench also, my lord.
Yes. You give me whatever you want.
Oh, lordship. Lordship, Page 29,
Two,
2929.
affidavit in reply.
That is, my lord. Evident reply, my lord. 2922 and 293.
290.
292, I have mentioned about the imminent domain of the petitioners, my lord. And 293, my lord, result of the unequal bargaining power of this state.
Para.
Para, my lord, 18, my lord. Para 18, 293, my lord. Then the deponent begs to submit that so far new appointment is concerned, it is a result of the unequally bargaining power of the state, which is inherent in the employment
Okay,
relationship.
show me your right to continue as a teacher after being properly appointed. That's all.
My lord, my right has been curtailed by then, my lord. I have a right, I have received salary up to 2012 or 16. No?
7, then 2012.
12, my lord. So, my lord, so far, supernumerary procedure, that is a job created post, my lord. This was the policy decision, my lord. Under that policy,
That
they
was a
paid.
mistake that did for accommodating excess teachers. You did not challenge that.
I have
You were
challenged, my lord.
accommodated against excess teachers at that point of time. You
I have challenged. So far, undertaking in concern, my lord, that was pursued, my lord. Before that, my lord, I have 3 representations, my lord. 3 representations. It is a dotted line contact, my lord. Similar situation handled by the Honorable FS Court, my lord. May I read, my lord?
Which case?
No. Yeah. Lordship. It is a forced labor, my lord. Violation of Article 23, my
Forced
lord.
labor because of the manner of entry. That's all. The government has done what it is to do.
Manner of entry so far, my lord. Similar manner, they are regular, my lord. Underage, they are regular, my lord, as per screening committee report.
Oh, you stick to your case, Mr.
My
Ahmed.
lord.
Forget what is happening in the world.
No. So far, credibility of the screening committee and their experts.
Challenge it. Challenge it and
I have
simply challenge it.
Illegally bargaining for free.
Otherwise, it will be foreclosing. Other than an appeal, there will be no other way out for you.
Illegally bargaining for
You have no objection to that? If they challenge the, withdraw this, challenge the,
I cannot have an
you
objection.
cannot have it.
No, my lord, I have a objection. I will not able to challenge, my lord. Already, my lord, some expert, only that their wife are before your lordship, my lord. Some already retired, my lord.
Okay, we'll stick to this. Yes. Anything more? What are the decisions?
Lordship. Illegally bargaining for হেইটো ক'ত আছে? 12. Yes. Yeah. This thing. This thing put.
Yes, para.
Lordship. Lordship, page 10, my lord, kindly, my lord. That is paragraph 17, my lord. May I read, my lord? So last portion is relevant, my lord. My lord, page 10, my lord. May I read from Article 14, my lord? In any case, the case where I guess Article 14 of the Constitution guaranteed to all persons equally before the law and equal protection of laws, my lord. This principle is that the court will not enforce and will, when called upon to do so, strike down an unfair and unreasonable contract or unfair and unreasonable clause in a contract entered into between the parties who are not equal in bargaining power. We are against the mighty government, my lord.
I can't go into that because that is not under challenge. I can only examine what is the challenge in the
challenge word, my
petition.
lord. I haven't write the word challenge, my lord.
No, where is the prayer to that effect? You have not even amended your writ petition to that effect.
It will apply where a man has no choice.
Mr. Ahmed, you have not amended your writ petition. You could have amended your writ petition. Now it's too late in the day.
That apart, lordship. We have filed several even before appointment and after appointment, my lord.
Okay, I think you are repeating the same thing. Nothing more is there.
No, my lord.
Any other decision?
Any other decision, lordship, that is lordship coordinate bench on this one. Forward. Okay. Sir. Sir, another decision, lordship, that's in 1986, CSCC 156, right?
1986?
CSCC 156. Here, lordship. Page 160, my lord. Contract which are unconscionable and
Rojanat
unfair.
Ganguly.
Lordship.
Rojanat Ganguly.
Lordship. Lordship is there, my lord. Take it or leave it, my lord. Even if accepted by the employee, liable to be declared void, my lord.
That is on a different context altogether.
Well, there is section 23, my lord. We have entered into contract with a service contract, my lord. They have obtained undertaking, my lord.
I'm sorry, until and unless that is under challenge, we will not consider.
To withdraw the WPC and entered. It is an unfair. Is it not an unfair terms, lordship, in the contract?
It's in pursuance to 1048 passed by this court. WPC 1048 Division Bench Court order.
Which one, lordship?
That procedure of screening is in pursuance to a policy adopted after 1048.
No, lordship. Lordship. 104 didn't say that. So for 104.
No, it didn't say or they said, I don't know, but the whole thing happened thereafter. My Lord Justice Ranjan and Bikesh.
Before that, there is a division order, my lord. They are said, my lord, when
You give me decisions, what you want to repair. Mahendra Nath Mohanto. What is this?
Division society asila performance. Lordship. The court appointed committees is a probably question. The court. Court appointed committee question. Court আছে না? Okay, page page 315, my lord. It is 1048 2004, my lord. Page 315, last paragraph, my lord. This Honorable Justice P.K. Sharma and R. Gogoi, my lord. Sorry, my lord.
We have seen it, no problem. It's on record.
My lord.
See it.
My lord,
Now
my
come
lord.
to the Mahendra Nath Mohanto.
When a court committee is already walking into the matters and committee is empowered to decide the validity of appointment and result, we have the view that that would be just for proper to refer.
That is that Sukendu.
My lord.
Chaji or some Talukdar committee. Now you are relying on Mahendra Nath Mohanto.
That, my lord, I may be allowed to show some credibility of the screening committee, my lord, because of their.
Without that challenge, we are not going into. We are only concerned with the prayers made in the writ petition.
The technicality, my lord, technically should be allowed to cross the genuine demand of the petitioner, my lord. It is so perfect. So far procedural
You
part
to
is.
be there legal, there is some basis for the appointment, I'll be with you. I'll set aside everything.
My lord, my appointment letter is
Appointment letter also does not reflect that that appointment is in pursuance to the recommendation of so and so.
All the already they have regularized my lord, 136 my lord, even retired persons my lord. Underage they regularize my lord. So all the regularized, that is 136 as per the screening committee bill, my lord, 136 teachers were found legal and regularized my lord. There also will find retired persons, underage. Those who spares the wrong day, my lord, victim the innocent, victim is the innocence. my lord.
Where is that incumbency list? You have an incumbency list here, wherein your names are there
16.
against post sanction.
Yes, yes, 16 also, no? No, see, I have put next year, madam.
Then that is the differentiation between Mohanto, not Mohanto, and your case. Yes, Mr. Anything more, Mr. Dhamma?
No, Lordship, so for Mohanar Kasmela 1528, that group was considered, Lordship.
But that was considered, it was,
158,
these
so for
people were
158.
excluded because in the incumbency list, their names were found. Fines mentioned in the incumbency list and those posts were retained under Nazira subdivision. So that is the distinguishing factor.
So far, judgment passed by the Honorable Bhuyan, Lordship.
That is in respect of those petitioners that cannot be have a normal application in your case.
No, madam. If court determines issue for certain sets of fact, that issue is then determined for all other purposes.
That has not been
that is settled,
implemented. We'll not apply that in your case. That is a decision of
No, Lordship, Supreme Court decision is there, my lord.
16. And the writ petitions were filed sometime in 2012.
All similarly situated teachers and
And petitioners were initially appointed against sanctioned vacancies under the non-plan.
Yes.
That is the distinguishing factor.
Yes.
I'm relying on the order passed by Honorable Bhuyan, which was attended finally, my lord.
Okay, we consider that. Anything more?
Lordship.
And their prayer was exactly this, that you have illegally included us in the supernumerary list. We should have been in the original list.
Whether they have cancelled the supernumerary list or not, my lord. Maybe that was a policy decision, my lord. Our fault was appointed post August 95, my lord.
Oh,
That was done, my lord, only for distribution of
you were
scholarship.
against those posts. Supernumerary.
Look, so the created post, my lord, however created, the teachers who is holding a created post can be a illegal and irregular, my lord. Lordship, kindly come to page 322, Lordship. Page 322, Lordship. Kindly, Lordship. The committee, Lordship, has found this. Committee will examine the list of teachers who working from 1991 to 2001. Different LP and ME schools, my lord. That was not followed, my lord. Exempted some.
And this petitioners in those cases which has been relied upon, they have also been considered under by the screening committee, teacher tutor.
Which fellow?
Decisions, earlier decisions of those.
Yes,
schools.
Lordship. Then Lordship,
Page 127. It starts at page 124.
Foreign Borgu and
Point one.
that I'll have to take.
What happened to the contempt petitions? It's pending.
contempt last 10 years, my lord. Because of they have already taken a step not to, they have already clearly said, perhaps it's not possible to obey the High Court's order. That stand continues, my lord.
Yes, Mr. Kaushik, what do you have to say?
Lordship,
Here in the
We'll come back to you, Mr.
এক minute. 1 minute, Lordship. Paragraph 3, no? 3 নম্বরতে কৈছিলে যে irregular বুলি এখনৰ যে 254 নেকি 254 250. Lordship, I kindly see the page 254, Lordship, of their additional their affidavit, my lord. 254.
Para?
That is, my lord. Para started from page 253. Paragraph
Para
5, my
30.
lord. 5 numbers of petitioner. 5 numbers of petitioner. Prince Saikia, Ratul Burgohai, Pramod Nayak, Abdul Rafiq, Bonti Gohai are found to be screening committee list, Sibsagar district, and petitioner not 10 were accommodated under theory. Tutor, all the 5 petitioners have accepted their appointments. The appointments letter were issued with a condition that the accommodated teacher will get the prospective effect and only he shall not.
Yes, we got it.
No, no, sir. Then thereafter, my lord, it is important, my lord. One petitioner, I, Rajkumar Shah, do not feature in the any of the expected 3 list from the screening committee report of Sibsagar district, as the petitioner did not receive any salary nor were trained. Hence, the petitioner was not accommodated in any post, my lord. It is a misleading statement made by the department. I can say the false statement, my lord. Already I have shown, my lord. Appointment letter, training, continuity, and my lord.
It is by a screening committee that is not on the challenge before. Why should I go into that? I'll only stick to the materials available. He holds the.
That is after your last discussion, my lord. Last 15, 16 years gone, my lord. Almost all half of the petitioner expired, my lord. Their wives are before your lordships, and they have no. I am also doing CIT lordship last 10 years.
We'll give it a closure. Don't worry. At least till the writ court is concerned, appellate court I can't say. Yes. Yes,
But in
Mr.
pursuance to the advertisement that was issued
Hmm.
by a policy decision taken by the government, they voluntarily participated in that process. And that committee was constituted only for the purpose of examining their claims of salary. Meanwhile, my lord, while the matter was pending before the screening committee, they have instituted this writ petition. So here in this,
When was the advertisement issued?
it was in 2012.
But they have not challenged that.
1 to 2012 and 4 to 2012. But they cannot challenge because they have voluntarily participated in that process. It was an open advertisement for all those.
Do you have that on record?
The advertisement, the statement we have made in paragraph number 7, Miller.
Page?
Page 157 of our affidavit. Internal page.
It is this.
And among those petitioners, Miller, those who have, there are petitioners, Miller,
Which para?
paragraph 7, Miller. In the last portion, the advertisement dates are given. This was pursuant to the office memorandum of 15/11/2011.
Now, have they filed a reply to this?
Yes, they have. Yes.
Page 274.
Yes. Paragraph 8, they have admitted that they have joined the screening process, my lord. And out of these petitioners, my lord, in this present petition, 20 of the teachers have been appointed as teachers, having found that they have the qualification.
10 as
Five as tutors
tutor.
and one has been left.
Anything more?
And look, as your lordship has very rightly taken note of, my lord, that there is no challenge to the findings of the screening committee, neither the policy decision of the government, my lord. And the petitioners having accepted the appointment order with that condition, they have relinquished their prayer that has been made in this repetition, my lord. That's all it is.
Lordship. Few seconds. Because since my learned brother is mentioning my lord voluntarily accepted, my humble submission, your lordship, kindly is 362, my lord.
No, Mr. Once you have submitted yourself to that advertisement,
Lordship.
otherwise your case cannot be considered. You had submitted yourself to that advertisement in 2011,
2012.
12. And then you filed this writ petition in
2017.
2017. You have not even dealt with that. Give me a second.
Lordship, whether we have accepted the appointment letter happily or it was forced, my lord, that I want to show, my lord. Before that,
Why
my
did
lord,
you participate? Why did you not challenge that in the court, that process that was initiated?
then we were asked, my lord, file a rejoinder, my lord. That person raised earlier, my lord. Then it filed an additional, bringing all these points, my lord. And director complained last,
Sir,
that is,
Ahmed, give me a second.
Lordship, Lordship. Sorry, Lord.
Please have a seat. Please have a seat. Yes. Yes.
Lordship, since my learned body has submitted, my lord, that we have participated voluntarily, my lord. So my humble prayer of your lordship and lastly, my lord. Page 362, my lord, and
You have already referred to traces.
then 365, my lord. 365, my lord. Before submitting documents, we ask that since we are not irregular, should we submit all these documents or not, my lord? The reference subject, I am to enclose here the copy of the so-and-so LP school. Application against the advertisement published in the newspapers, that is so-and-so, so-and. The payer of the petitioner cannot be
And
considered.
this document was there with you.
You are
Dilip
requested,
Tati had this document in 2012 itself.
12 which.
After 5 years, you filed the writ petition. This was never challenged.
you are requested to direct them to submit their application as per advertisement.
Oh.
Because we are not
The prayer
required.
of the petitioners cannot be considered. You never made a challenge.
My lord, each and every step challenge, there will be hundreds of writ petitions.
No, I'm not on that. When you came in 2017, you had this fact. You never disclosed that. That you had participated in you were required to participate in the screening process, although you are not a part, you were not covered by the illegal.
So participation was, my lord, forceful. That is my humble
No,
submission.
the advertisement in pursuance to the advertisement.
My lord.
The participation cannot be forceful. It is your voluntary act. There was an advertisement, you submitted your application.
So for new appointment is concerned, my lord.
I'm not on that.
My lord.
I'm on the initial part.
Lordship.
Mr. Ahmed, there was an advertisement in 2011.
Lordship.
You admit that you participated.
Participating.
Why did you not challenge that before this court when you filed the present writ petition?
That time, Lordship, I was getting the regular salary and all, my lord.
Okay.
No dispute arises, my lord. So my humble submission with your lordship, my lord. It's a, my lord, the delicate issue, my lord, requiring very circumstantial approach is rooted, my lord, because whether they have accepted the undertaking.
These are all public money being
Happily,
utilized.
my lord.
Our private interest cannot be our public interest.
My lord.
An illegal appointee cannot claim that he should be given all benefits. I'm
No,
sorry.
I am not illegal, my lord. Court declared us as a legal, my lord. They have not a single documents, my lord.
Where is your declaration by the court that your appointment is?
Lordship,
Just show me the incumbency list in your case or your select list. That's all.
select list was not.
Then?
But those who are already regular, they have also not any select list, my lord.
Bring them, file a case, bring them, we will set aside.
No, that is my lord. My lord, my humble saying for lordship, my lord. Just to
Okay, you did not challenge the advertisement of 2011.
No.
Fine. But where is your clarification in the thing that that process cannot be made applicable to you for X, Y, Z reasons?
that process I didn't challenge, my lord. That process I didn't challenge.
Anything more?
My lord.
Like-
My lord, my humble saying for lordship, my lord. My lord, lordship is to decide, my lord, whether the acceptance was or the undertaking.
No, that is not under challenge. We will not go into that.
I have made a category as per the court order. I have made
Because you have not even challenged the initiation of that process.
no category said, my lord. Court was asked I have to file documents in my rejoinder, my lord.
Okay.
My lord, whether it was a violation of Article 14, 16, 21 or what, my lord.
I'll pass the order at 2 o'clock.
That upon, my lord, where the executive, my lord, exercising Article 162, my lord, can nullify, my lord, judgment already pronounced, my lord.
Where is that judgment in your favor?
My lord, that is,
That cannot be.
my lord,
That cannot be. They came in 2011. They may have made challenge to all those things. And
My
then
lord-
they might have got that judgment. We don't know.
no, it was
And the
final.
court says that The
This case was
supernumerary,
final
there is a
79.
distinction made.
In fact, having participated in the process in 2012,
You cannot.
the petitioners were even stopped from filing this petition, claiming the salary.
Yeah, next.
Should may kindly pass over the matter. The conducting counsel is on legs in court 7.
Let him continue in court 7. We'll hear the petition.
My senior is next, report number 10. Present.
As both the learned counsel for the parties are stated to be on legs, registry to list this matter again after the ensuing summer vacations on a date to be fixed by.
If possible, to them,
Hmm?
if possible, to them, timing,
We have matters in.
deep level. May I please the lordship. Lord, in this case, my lord, the petitioner school was established in 1995. There are
Just show
some-
me your application for dice data. Mr. We'll take it up at 2. 2. Duta was at inform the other side also. Duta was at.
Well,
Yes,
page number
show me the application submitted by you for inclusion in his dice code.
Page number 15, my lord.
Huh?
Page number 15, my lord.
15, 1-5.
1-5. Well, actually, they are, before submitting this representation, they actually applied before the CRCs.
That has been denied.
copy has
There is
that-
your rejoinder to that denial.
Well, we can see the page number 18, annexure number 6, page number 18, Lord,
1-8.
on it. So there is one is block element.
This is 2015.
Yes, my lord.
That will not help you because it is 2009 and 10 in the.
Prior to 2009 and 10, the petitioner regularly submitting the application, representation for dashboard, but they are denying, my lord.
Come to page 35. An application will not do, mister. You will have to submit the data.
Yes, my lord. As per their affidavit, there is no any
Record.
data information.
So that's the end of the
They
matter.
are not considered there.
That is, we are not concerned. We are concerned whether
There is no bar to give
now
the
you want a
dashboard.
dice code for the year 2009 and 10. How can that be issued today? You filed this
Sir,
petition in 2020.
2014 or 15 may be given. There is no bar, my lord.
2020, how can they give it retrospective? Who will do the inspection? You may have that power to look back.
My
We
lord,
don't have, the authorities will not have.
Annexure 7, my lord.
Give me a second, just a minute.
Sub inspector inspected the matter regarding 2014 and 15.
Anything more, Mr. Counsel?
But the inspection report is there, Annexure 7 regarding 2014 and 15 dashboard, my lord. There is,
You see your prayer. You filed this petition in 2009, 2020. Praying for that. I don't know how this petition was alive.
This petition may be disposed of on the basis of the.
But you take appropriate steps. If you want even now to be your name to be included in the dice code, you take appropriate steps.
Yes, my lord.
But Mr.
D.U.
D.U. Ahmed, learned counsel for the petitioner. None appears for the respondents on call. Usaf. Madam, you are appearing for? Miss. Miss. Madam, your name, full name? D.B. D.B. Gugoi, learned government advocate appearing for the respond number 5. None has
On behalf of B. Gogoi, my lord.
Mr. H. Borua, learned counsel appears for the SSA respondents. That is the respondents number 3, 4, 3 and 4. 3, 4, 9. 3, 4 and 9. None has appeared for the other respondents. The petitioner in the by way of instituting the present writ petition on 19/10/2020 has prayed for a direction upon the respondent authorities to provincialize the petitioner school, namely Pasimpar Mohan VLP school, if necessary, by issuing dice code for the year 2009-10. Also, as projected in the petition, the petitioner school was established in the year 1995. Also, it is contended that after the establishment of the said school, the same has been functioning. You are a LP school?
LP school.
As a lower primary school. Also, in the year 2004, the authorities of the Sarva Shiksha Abhiyan mission had introduced a data information system of education for accountability of schools towards the mission in Assam. In terms of the said policy, the headmaster of the school, being the ex officio secretary of the school managing committee, is required to submit an application in the prescribed format before the CRCC of the locality for capturing the data of the school in the data information system. Also, the school concerned on making such application is given a DISE code. Also, the petitioner in the petition has projected that wide a representation dated 7/10/2009. The principal of the school had approached the block mission coordinator, South Karimganj block, praying for forwarding of its documents to the district mission coordinator, Karimganj, for inclusion of the school in the DISE data. Such applications were being found, were thereafter contented to have been submitted at regular intervals. The school, in absence of a DISE code being granted to it, being kept outside the purview of provincialization exercise undertaken by the respondent state, had instituted the present writ petition. The learned counsel for the petitioner, reiterating the facts noticed herein above, has submitted that the existence of the school is not in dispute. However, in absence of a DISE code being granted to the said school, comma, the school has been kept out of the purview initially of the Assam 2011 Act, Pura, and presently from the purview of the 2017 Act. Accordingly, he submits that direction is required to be issued to the respondent authorities to grant a dice code to the school from 2009-10. For B. Gogoi, Learned, Standing Council. Now it is called Samagra
Shiksha Abhijan.
Samagra Shiksha Abhijan, bracket earlier. Shiksha. Earlier it was Assam Shiksha.
No, Sarva Shiksha Abhijan.
Sarva Shiksha Abhiyan.
Sarva Shiksha Abhijan.
Issued dice code as of 2009-10. So, Mr. B. Gogoi, Learned, Standing Council, SSA, has submitted that the school admittedly was not granted a dice code. He further submits that for the purpose of grant of a dice code, the head teacher / headmaster of the school is required to fill up the dice data capture form duly signed by him with his seal and forward the same to the CRCC. To the cluster resource center coordinator. Port likhi CRCC. The CRCC thereafter shall verify the particulars as incorporated in the application form and the same would be placed before the block elementary education officer, block mission coordinator for counter signature before it is submitted at the district level for entry in the DICE software. He submits that the petitioner in the present petition has not brought on record any such application form, any such DICE data capture, any such particular submitted in the DICE data capture format. So the petitioner, accordingly, he submits that the prayer of the petitioner made in the present petition cannot be considered. So, Mr. Gogoi has further submitted that it would not be possible in absence of the requisite data of the said period to now issue to the petitioner a DICE code for the year 2000, right? 2009-10, right? That is the, can you issue?
That we'll have to verify, yes.
You can issue from today also, 9-10.
That will be probably difficult, man.
That's what
Yes.
it says. So he, however, submits that in the event a fresh application is submitted in the procedure by maintaining the procedure, by maintaining the procedure mandated, the SSA authorities shall consider the same for allotment of a DICE code to the petitioner school. I've heard the Learner Council for the parties and also perused the materials available on record. In the present writ petition, although the school has been stated to have been established and functioning since 1995, the petitioner school has not brought on record any application submitted in the prescribed format by the head teacher / headmaster of the school for inclusion of the school in the DICE data. So, the respondent SSA in the affidavit filed by it in the present proceeding has contended that the procedure as mandated for allotment of a DICE quota requires the head teacher / headmaster of the school in question to submit a filled-in DICE data capture form DCF capture form duly signed by him to the concerned CRCC. Thereafter, the particulars data incorporated in the DCF, data capture format, is to be verified by the CRCC and placed before the block elementary education office, block elementary education, jurisdictional block elementary education officer, block mission coordinator before for counter signature, and it is only thereafter that the concerned authorities of the district, it is thereafter only, and it is thereafter, and it would thereafter only be permissible for the concerned authority at the district to enter the data in the DIAS software. He submits that the petitioner, it is seen that the petitioner has not brought on record any material to demonstrate that the procedure as mandated for capturing the school in question in the DIAS data has been complied with by it. So, there is no rejoinder filed to the affidavits filed in the matter by the SSA authorities. So, in view of the above position emanating in the present matter, this it would not be permissible for this court, in absence of any verified data being available of the school for the period 2009-10 to direct the respondent authorities, more particularly the SSA authorities, to issue a DIAS code to the petitioner for the year 2009-2010. Accordingly, the claim made by the petitioner in this connection stands rejected. However, it is provided that in the event the petitioner submits the requisite particulars of the petitioner in the manner as noticed herein above before the respondent authorities shall, on verification of the same, proceed to include the pool of the petitioner in the DIAS data format, DIAS data, and also issue a DIAS code to the petitioner. Also, the petitioner in this connection may approach the concerned authority by way of submitting the requisite data in the prescribed format within a period of 1 month from today. Also, with the above observations and directions, the present petition stands disposed of.
Only thing, if found eligible, because you will submit the documentation.
I'll put it.
Yeah. Along with
Approach,
24 days.
on verification, if found eligible.
Lordship, my senior is on legs. The matter may be passed over for the time being.
What is the data? What is the instruction?
Lordship, I don't have the instruction with me.
Well, what is this? We only required an instruction, nothing more. There is no argument required here.
Lordship, my senior is conducting the case, so I'm not aware of it.
450, not much, but my last item. Which court?
Number 20 or
Take time. Last item.
Yes.
But if you don't get it, the none is appearing on the next call, we will direct for complete full payment to the petitioner. $11,000. What is motion? 17, 18, as well.
Timing loss.
Next week go, next week go. That to
No, I'm also not.
next week, Mala.
On the prayer of the learned counsel for the parties registered to list this matter again after the ensuing summer vacations.
গাটো ভাল নহয়।
But 18 to 22. Okay, we are not taking up any matter. Any urgent matter? Any urgent matter? Because advocates are not here, so we are not taking any matter. Just calling the matter, wasting our time, we are not concerned. Any urgent matter can make a mention. Those we are rising.
Hearing matter is there, Lordship.
Yes, which one?
It's already hard. I think item number. Hearing matter.
53.
Yes, Lordship.
Oh, take it up. Yes, any
Item number 24 may fix.
fixing we are not doing. If you want to do urgency is there, tell me.
Affidavit.
Lordship, as regards, sorry, Lordship, as regard item 1, Lordship,
We are passing the order today.
today, Lordship.
We are passing. We are passing after just this matter. We are taking up that.
Lordship, please.
33, your lordship. Is there, your lordship has heard this matter.
Okay, matter. Both sides are present. That's it.
33.
Nobody is appearing. I don't know why.
33.
No, the other side is not there, Mr.
No, it's 33, your lordship's higher education.
Higher education.
Lordship, as thus is happening, this is, he's in
Oh,
matter
very
for-
busy. They are very, very big matters. I'm rising. I'll tell the Chief Justice not to give me matters.
No, Lordship.
Yesterday, 12 matters constantly. This was the thing.
33.
We are here to do work, not to just while around.
Lordship, he's-
In fact, your lordship,
he's
in
stuck in
my
other-
item 33, your lordship have heard the matter. This is an appointment in a college, your lordship, grade 3 employee, your lordship. All the others from the same advertisement was appointed, your lordship.
Yes. Any additional affidavit file?
We have filed, your
No,
lordship,
no. They wanted to file an additional affidavit.
No. On last occasion, standing counsel submitted that he has left it to the court, honorable court. Take call. Additional affidavit we have filed, your lordship.
You have filed.
Lordship.
Just give me a background.
Lordship. Here, your lordship,
I'm stopped reading files. Why should I read it?
we suffer, your lordship.
Can't help it. Yesterday, 14, 15 items serially.
Lordship.
None had the occasion or audacity to come and appear. Yes.
There is an advertisement, your lordship. In that particular advertisement is, you will get it at page 22. That, your lordship, advertisement for filling up various posts of your lordship. Grade 3 post, your lordship, in this particular college, your lordship, Bhavanipur Anchalik College, your lordship. Now we are concerned with the 7 junior assistant, your lordship, unreserved, lordship. Now, your lordship, this is the second round of litigation. In that particular interview I was called, your lordship will get it the comparative seat at page 26. I received highest mark, your lordship. Jim Committee, your lordship will page 27, serial number 16. 60.993 total marks, your lordship. And instead of me, your lordship, someone else was appointed, your lordship. One Himanshu Das, your lordship. Your lordship get it at page 29. Serial number 4.
40 something.
Lordship. Now your
Serial
lordship.
number?
Serial number 4, your lordship.
Then what happened?
Now, your lordship, at that point of time, I challenged that, your lordship, the order at page 40.
40.
40. The selection was set aside, and then your lordship will kindly come to page 44. Para 10. In that view of the matter, this court is of the view that selection of the respondent number 7 over the petitioner seems to be arbitrary and unreasonable. Accordingly, the selection of the respondent number 7 by selection committee is hereby set aside. The director is directed to take decision as to whether the petitioner or the respondent number 7 should be appointed to the post of junior assistant of college
on the basis of the marks secured by the candidates in the selection process pursuant to the advertisement of the so and so. The matter is not being remanded to selection committee reconsideration on account of reasons stated above, wherein appears that selection committee has not been fair in selecting the respondent number 7. The entire exercise should be concluded in a reasonable period. Then, your lordship, they have passed the impugn order at page 47, your lordship.
The advertisement is rooster point number 7,
Lordship,
not 10.
not 10, your lordship. Then your lordship will kindly see the order at page 47.
Page 7. That is the order of the director.
Director, he says that it is not
That's purpose.
Lord. Then your lordship, I came before this honorable court, your lordship.
What is the stand in the affidavit?
Then their stand is that this should be the same stand that has been taken in the order, your lordship. Your lordship will kindly come to page 48 is their affidavit, and para 6, your lordship. They said that this was not the guideline. This guideline ought to have been followed, your lordship, 28/4/2017. Which they have not annexed, of course, your lordship.
But if that guideline is the guideline is for all the posts.
Lordship.
What have you brought on record in the?
That the other candidates, your lordship, who were selected by the same process, your lordship, they were continuing, your lordship, in service. The director has given approval to the selected candidate. Then your lordship, he was appointed. When my turn came, your lordship, then suddenly she can remember that there is another guideline, your lordship. And in fact, I have filed my reply, and in the reply I have shown, your lordship, that is not the fact, your lordship. Even in their website, only the 22 guideline is available, your lordship.
Take us. Done. Anything more?
Lordship, that.
But Mr. S, you have nothing to say? But Mr. S. Bhattakur, learned counsel for the petition. Learned senior counsel appearing for the petition assisted by Mr. E. Gugui. Learned counsel for the petition. Also heard Mr. S. Learned standing counsel, higher education department appearing for the respondent number.
Respondent number 1, 2, 3.
1, 2, and 3. The petitioner in the present petition has presented a challenge to a picking order dated 24/4/2025 issued by the Director of Higher Education, interfering with the selection made in respect of a post of junior assistant grade 3 in Bhawanipur Ansolik College in pursuance to an advertisement issued for the purpose on 15/3/2023. There were 2 posts. What happened to the second post?
Lordship, junior assistant, your lordship, grade 3, unreserved.
What happened to the reserve post?
So, entire post are appointed, then your lordship, they are continuing, your lordship.
Where is that person? You have brought it in the affidavit?
Lordship, my additional affidavit, your lordship.
What is his name?
77/79, your lordship.
77 to 79. Yes.
One is Parthopratim Bormon, your lordship. The other one, Nobojyoti Uzir, junior assistant.
Nobojyoti Uzir is set aside.
No, your Himangshu is set aside. Your lordship.
How many posts were there?
I have applied for one, your lordship.
No. How many total posts were there?
Lordship, that your lordship will get it at page 22. Junior assistant, your lordship. 4 posts, your lordship. Grade 3. 1 unreserved, 1 scheduled caste, 1 Unreserved and 4 is OBC, MOBC. We are concerned with that, your lords.
2 unreserved, 1 SC,
Lord.
1 OBC.
Lords.
What happened to SC
They all were appointed, your lords.
against that?
Lords.
OBC also appointed.
Lords. OBC,
brought
I am
the-
concerned with this OBC post.
You're concerned with OBC. So that UR was appointed, 2 UR was appointed and 1 OBC was appointed.
Appointed.
1 SC was appointed.
One SC was appointed.
You have got the names?
Lordship. That is there, your lords. Page 29, your lords. Out of this, your lordship, Prohibitions appointment was also set aside and passed by this honorable court in another writ petition.
What happened thereafter?
Thereafter, that what has happened, I don't have any instruction on that. But this Navajyoti Ujir and Parthapratim Bormon, they are continuing.
Huh? Challenge to Dilun. So, as projected in the writ petition, the petitioner herein, in pursuance to an advertisement issued by the authorities of the Bhawanipur Insoli College on in pursuance to an advertisement issued by the authorities of the Bhavani, advertisement dated 15/3/2023 issued by the authorities of the Bhawanipur Insoli College, had submitted his representation for recruitment. Mr. Please have your say. Recruitment against the one of the posts of junior assistant as advertised for OBC-MOBC candidates. The petitioner, in pursuance of the application submitted by the petitioner, being found to be suitable, found to be conforming to the eligibility criteria as mandated for recruitment to the post of junior assistant, junior assistant, the petitioner was permitted to participate in the selection process. Also, on conclusion of the selection process, it was found that the petitioner had secured 60.993 marks, which was the highest marks secured by a candidate appearing for the post of junior assistant reserved for OBC/MOBC category. Also, however, the petitioner came to learn that subsequently the petitioner came to learn that the selection committee had recommended one Himanshu Das against the post of junior assistant reserved for OBC/MOBC category. Also, being aggrieved by the recommendations made in respect of the respondent number, in respect of said Himanshu Das, the petitioner had approached this court by way of instituting a writ petition being WPC number 4197/2024. A coordinate bench of this court, wide order dated 4/4/2025, upon examining the issues arising in the said matter and also considering the marks secured by the petitioner and said Himanshu Das, who was arraigned as respondent number 7 in the said proceedings, proceeded to interfere with the appointment effected in respect of the respondent number 7. So, thereafter, the matter was remanded back to the Director, Higher Education, for arriving at a decision as to the suitable candidate now required to be so appointed against the post of junior assistant reserved for OBC community candidates advertised with the advertisement dated 15/3/2023. Also, in pursuance to passing of the said order dated so and so 4/4/2025 by a coordinate bench of this court in WPC number 4197/2023, the Director, Higher Education Assam, proceeded to pass a speaking order dated 24/4/2025, rejecting the claim for the petitioner for appointment against the post of junior assistant reserved for OBC candidates widely advertised widely advertisement dated so and so 15/3/2023 on the ground that the selection procedure as conducted for recruitment to the said post was erroneous. Accordingly, the director, while interfering with the appointment effected in respect of said Himanshu Das, proceeded to cancel the entire selection process for the post of junior assistant reserved for OBC, MOBC candidates. Being aggrieved, the petitioner has approached the as instituted the present petition. Mr. S. Bodhaku, learned senior counsel, reiterating the facts noticed herein above, has submitted that in the advertisement dated 13/3/2023, it was categorically stipulated that the selection procedure would be that which has been laid down in the office memorandum dated 28/7/2022. He submits that the selection process for all the posts advertised wide the advertisement dated 15/3/2023, including the post of junior assistant, grade 3, was so carried out by following the procedure laid down in the said office memorandum dated 28/7/2022. Mr. Bodhakur has further submitted that while the said advertisement dated 15/3/2023, 4 posts of junior assistant were so advertised. Out of the 4 posts advertised, 2 posts were so advertised for general, advertised as open category post, while 1 post was advertised for SC category candidates and 1 post for OBC-MOBC category candidates. He submits that the director, after having interfered with the appointment of the director having interfered with the selection so made in respect of the post of junior assistant reserved for OBC-MOBC category candidates as advertised while the advertisement dated 15/3/2023 has not interfered with the appointments effected through the same selection process for the other 3 posts of junior assistants advertised while the advertisement dated 15/3/2023. He submits that in the event the advertisement made against the post for which the petitioner had secured the first position by not complying with the prescribed procedure, the same yardstick was required to be also applied in respect of the other posts advertised while the advertisement dated 15/3/2023, including the post of junior assistant. Accordingly, he submits that the contentions raised by the director in the speaking order dated 24/4/2025 is clearly perverse and the same would mandate an interference. Mr. Bodhaku submits that on interfering with the said speaking order dated 24/4/2025, this court would be pleased to direct the respondent. This court would proceed to direct the respondent authorities to appoint the petitioner against the post of junior assistant advertised while the advertisement dated 15/3/2023 for OBC/MOBC candidates. You have nothing to say?
Yes, I have nothing to
Madam,
say.
so-and-so. Appears for the respondent number. Miss
325.
Khatunia, Learned Counsel, appears for the respondent number
325,
325.
3, 4, and 5.
Miss S. Khatunia, Mr. S. Das, Learned Counsel for the S. Mia. You have something to say? You have something to say? submits that as Mr. S. Das is appearing and had made his submissions on the earlier date, no further submission is called for to be made on behalf of the Higher Education Department. I've said no further submissions
Paragraph number 6 also.
of the affidavit. Mr. S. Mia, Learned Counsel, Learned Standing Counsel, appearing Higher Education Department submits submits that the selection procedure as mandated for recruitment mandated to be followed for recruitment against the post of a grade 3 post in a provincialized college was laid down by the respondent authorities. Why is the procedure laid down by the respondent authorities via an office memorandum dated 28/4/2017. He submits that on the date when the advertisement in question was so issued, it was the provisions of the said office memorandum dated 28/4/2017 that was required to be followed by the selection committee by the college authorities for effecting recruitment against grade 3 posts, vacant grade 3 posts in the college. Mr. Das submits that the college had committed an error in proceeding to conduct the selection in question in pursuance to the advertisement dated 15/3/2023 by relying on the office memorandum dated 28/7/2022, although the same was not applicable. Mr. Das, Mr. Bhuya, however, does not dispute the contention raised by the petitioner, senior counsel for the petitioner, that it was the petitioner who had secured the highest marks against in the selection held against the post of junior assistant reserved for OBC, MOBC candidates in pursuance to the advertisement dated 15/3/2023. So it is submitted that while the appointment made in respect of one Himanshu Das was set aside on the ground that he had secured much lower marks than the petitioner in the selection process, the entire selection was required to be set aside on noticing that the selection was not so conducted in accordance with the guidelines holding the field, that is the guidelines notified by the office memorandum dated 28/4/2000, laid down by the office memorandum dated 28/4/2017. Accordingly, he submits that the claim made by the petitioner in the present petition would not mandate an acceptance from the school. Ms. S. Khatonia, Learned Counsel representing the respondent number 3 and 4 has submitted that you have not filed an affidavit.
We have already filed affidavit, Your Honor, regarding that in my affidavit in reply, where I have an enclosed one is Nabojiti, Bormon, and they have been selected on basis of the merit list. Paragraph, Your Honor, in my affidavit in paragraph number 4. And page number 83.
Okay, it's typed as affidavit in reply. Page number?
Page number, running page 83, paragraph number 4. And I have enclosed that on serial number 106 and 122, Sri Parthapatim Barman and Sri Nabojyoti Uji, they have selected on the basis of the merit list. And I have enclosed a merit. They are in serial number 106 and serial number 122.
Then why did you initially select that other Himanshu? That is no reference. Okay, submits that. The selection in question was a selection in question to the post advertised. Why the advertisement dated 15/3/2023 was carried out by the college authorities in terms of the guidelines laid down in the office memorandum dated 28/7/2022. She submits that by applying the same very guidelines, the one Nabojyoti Uji and Parthapatim Barman were also recruited to the post of, were also selected for appointment against the post of junior assistant against the post so advertised for general community candidates. So advertised in the open, under open category, why the said advertisement. He submits that the against the said recruitment made, no anomaly was pointed out by the Director of Higher Education in the matter, and they are continuing.
They are continuing their service.
And the said appointees are continuing in their services till this very date. So I've heard the Learned Council for the parties and also perused the materials available on record. The authorities of Bhawanipur Ansolik College wide an advertisement dated 15/3/2023, amongst others, advertised 4 posts of junior assistant. So, the breakup of the 4 posts so advertised was as follows. 1, Roman 1, Polo TV. You are against Rooster Point number 7. SC bracket against Rooster Point number 8. You are against Rooster Point number 9. OBC dash MOBC against Rooster Point number 10. It is to be noted that along with the said advertisement, the advertisement further stipulated that the educational qualifications requisite to be so possessed by the intending candidate, as well as the selection procedure to be followed by the selection committee, will be that so prescribed by the government in its office memorandum dated 28/7/2022. In its office memorandums dated 24/1/2022 and 28/7/2022. So, the petitioner, having found himself to satisfy the eligibility criteria set out for recruitment to the post of junior assistant in a provincialized college, and he belonging to the OBC community, proceeded to submit his application for consideration of his case for recruitment against the post of junior assistant as advertised widely advertisement dated 15/3/2023 and reserved for OBC-MOBC candidates. On conclusion of the selection process, the comparative merit of the candidate from the comparative merit of the candidates participating against the post of junior assistant reserved for OBC/MOBC category, it is seen that the petitioner had secured 60.993 marks which was the highest mark secured by a candidate in the said category. Also, however, the respondent college, while proceeding to recommend the names of the selected candidates to the Director of Higher Education for approval, proceeded to recommend the name of one Himanshu Das against the post of junior assistant reserved for OBC-MOBC category, although Mr. Himanshu Das had secured much lower marks than that of the petitioner hearing in the connected selection process. Next, the petitioner being aggrieved had instituted a writ petition being WPC number so-and-so 4197/2024 before this court. A coordinate bench of this court wide ordered it 4/4/2025 proceeded to dispose of the said writ petition by holding that an illegality was committed against the petitioner herein, as he had secured higher marks than the respondent numbers. Then Himanshu Das bracket, who was arrayed as respondent number 7 in the said writ petition bracket over in the selection process. Having drawn the said conclusion, the matter was disposed of with the following direction. Direction, para 10. Accordingly, a perusal of the said directions passed by this court by the coordinate bench of this court would go to reveal that the appointment of the respondent number 7 as junior assistant in the college was interfered with. Also, the petitioner had thereafter furnished a copy of the said order dated so and so passed by the coordinate bench of this court before the Director of Higher. The Director of Higher Education Assam thereafter, on consideration of the issue arising before him, proceeded by the speaking order dated 24/4/2025 to set aside the entire, to cancel the entire selection process for the post of junior assistant reserved for OBC/MOBC candidate. The speaking order being relevant is extracted here in below, page 47, A to A. A perusal of the said order would go to reveal that the director, after noticing that Himanshu Das was appointed to the post of junior assistant in roster point against roster point number 10, reserved for OBC/MOBC, had noticed the order dated 4/4/2025 passed by the coordinate bench of this court, also, and thereafter proceeded to verify the records and found that the selection committee decision in recommending the name of Himanshu Das, said Himanshu Das, was arbitrary. It further proceeded to hold that the selection committee decision was not as per the procedure laid down in the relevant guidelines/OM. Having drawn the said conclusion, the director further held that since the selection procedure for the post of junior assistant against roster point number 10 bracket reserved for OBC/MOBC bracket over was erroneous, this directorate has deemed it fit to cancel the entire selection process of the said post. Accordingly, it was held that although the petitioner herein had obtained the highest marks, he cannot be appointed to the said post as the selection process was erroneous. So, no further reason has been disclosed in the said speaking order dated 24/4/2005 as to why the selection procedure was held to be erroneous. The gap as existing in the order dated 24 2025 in this connection is sought to be filled up by the respondent director of higher education in the affidavit filed by her in the present proceedings. In the present proceedings, the director in the affidavit has projected that the selection in pursuance to the advertisement dated 15/3/2023 being so carried out in terms of an office memorandum dated 28/7/2022, the selection process was held to be erroneous. It is projected that the selection in question in pursuance to the advertisement dated 15/3/2023 was to be so carried out in terms of an office in terms of the guidelines laid down in an office memorandum dated 28/4/2017. Also, while the said projection was made by the director in the affidavit filed in the present petition by her, the director has not proceeded further to explain as to why the said yardstick was not so applied in respect of the other three posts of junior assistant advertised wide the advertisement dated 15/3/2023 and the selection for which was also held in terms of the office of the guidelines laid down in the office memorandum dated 28/7/2022. In the event the procedure that was followed for recruitment against the post of junior assistant reserved for OBC oblique MOBC candidate, while the advertisement dated 15/3/2023 was so carried out because the procedure mandated in this connection by the respondent by the competent authority of the Department of Higher Education, the same very procedure being followed in respect of the other cases also would have mandated the selections made against the other posts of junior assistant to also be interfered with. However, such interference is not found to have been made, and the respondent number, the counsel for the respondent number 3, as well as the petitioners, by bringing on record further pleadings, have contended that the candidates so recruited against at least against two posts of, we'll put it at least against two posts of junior assistant, which were advertised in the open category, are still continuing in the said college, and no objection to their such continuance has been taken. Also, in view of the above conclusion, this court finds that the reasons are cited by the submits that that there being no justification set out by the Director of Higher Education in the speaking order dated so and so 24/4/2025 for cancellation of the entire selection process, and only a vague projection being made that the selection process was erroneous, this court finds that the same to be a non-speaking order and the reason assigned to be not proper. Accordingly, the order dated 24/4/2025 stands set aside. This court also notices that the reasons as advanced by the Director of Higher Education for cancellation of the in the selection process in the affidavit filed would be of no consequence, inasmuch as it is a settled position of law that an order must stand or fall on the basis of the reasons assigned in the said order, and the same cannot be supplanted by reasons submitted subsequently in the affidavit. Refer MS Gilbillet. MS Gilbillet. So, further, this court has also noticed that even if the reasons assigned in the affidavit is taken out of, the same would also not be mandated to be accepted, in as much as an apparent discrimination is made out therefrom against the petitioner inasmuch as while the petitioner's selection was cancelled, the other select made for post of junior assistant advertised against the open category. By the advertisement dated 15/3/2023 by applying the same very selection procedure as applied in respect of the petition was not interfered with. Accordingly, for the reasons assigned herein above, the speaking order dated 24/4/2025 stands set aside. The Director of Higher Education Assam is directed to issue orders appointing the petitioner as a junior assistant against the post or reserved for MOBC candidate by the advertisement dated 15/3/2023. 15/3/2023 by reckoning that the petitioner was the candidate securing the highest marks in the connected selection process for the said post. The appointment order of the petitioner be issued within a period of 15 days from the date of receipt of a certified copy of the present order. Done. Anything more?
Lords.
With the above observations and directions, the present writ petition is
Lodge.
not be uploaded today. It will be uploaded Monday.
Lords, as per your lordship.
My lord, in regard to my lord, item 47, my lord, my learned senior is the petitioner, my lord. In this case, our instruction is awaited, my lord. May I pray this matter may come after 4 weeks.
Okay, we'll see when it reaches.
Obvious.
We made a note of that 47 note.
Deeply.
If I reach there, I'll see. Mr. Monto, Mr. Chaudhary, why are you here?
I thought there is item number 35 further hearing, Miller.
Oh, that.
Mondal, Miller.
And Mr. Monto, you are?
37. All matter, it will not take.
Oh, small matter, I know. Because in my court, a new trend has started. Nobody appears. Everybody is on legs. We don't have that much court here for everybody to stand together.
Lord, in this case,
That matter.
Lord, kindly similar, what is my fault, Miller? I gave a report. I said that the patta there is somebody else. There is a requirement of hearing. The circle officer says he is not to be blamed. Now, please have come to the show cause notice, Miller, page 92. Can it be construed as a show cause notice first?
They were supposed to, I think, produce the records.
Yes. I think they are ready with the record.
Records have come.
Yes, so the records are here, lordship. But thing is, the lordship, the Miss M. Bhattacharya will be appearing in the matter. She is on legs at court number 4. So I have already informed her.
It's okay. It's okay.
Kindly see, my lord, as per the report, Thurs number 1, Deputy Commissioner Crime, when you were posted in the office of Circle Officer Gauhati Circle, you were arrested in connection with Borlomuk PS case number so and so. Therefore, you were charged with violation of section 3. What is this, my lord? Merely because somebody is arrested, where is the question of invoking 13, my lord? Then 2, when you were posted in the office of Circle Officer Gauhati, you as a public servant.
Any statement of allegation attached?
Nothing, my lord, nothing. This is the one, and next page is the page 93, my lord. List of witness. Aminul Islam inspector and list of document. I'll show your lordship this document at page 90A. In fact, the circle officer has cleared me, my lord. Please come to page 98 regarding that note.
90?
Page 90, capital A, my lord. 90A. Please come to that note after para 2. Subsequently, the then circle officer Sri Satyajit Dwara was also arrested, and during interrogation he disclosed that Latmondol had no role in the
You are the last Mondal.
I am the Latmondol. Now, number one, it is not a shoko. Number two, there is no evidence. How can there be a punishment of dismissal?
Mr. Chaudhary, are you carrying those decisions? That the charge, if the charge is vague.
Yes.
Just give me that.
Yes. There are two judgments, my lord. Take the difference. My lord, left hand side top, I have indicated the paragraphs.
Because yesterday I promised to myself I will not read a brief. I did not read. I went back and I slept.
My lord, yesterday there was a judgment delivered by Honorable Supreme Court. Today it has been reported in Times of India that for some offense, for some misconduct like insubordination, etc., where financial implications are not involved, where moral turpitude is not
My
involved.
Lord Justice, doctor's judgment.
No, my lord. Honorable Justice Carroll and Honorable Justice Koteshwar Singh.
Oh.
Today it has been reported in Times of India. Dismissal should not be avoided.
Proportionality.
Proportionality. Basically proportionality.
Yes, which is the 16 and some. That's a good development. Because we did not have a direct judgment on that.
Yes. Today it has been reported. I think day before yesterday the judgment was delivered. Today, this morning I read in Times of India. Times of India and Indian Express, the legal reporting is very good.
It's very good.
In Indian Express to aru bhalo.
And Surat Chandra Chakraborty, yes.
My lord, regarding my lord, my role, please see, my lord. Report by my report, first report is at my lord 11.4. What is the wrong I have committed? I fail to comprehend, my lord. 11.4 to go to page. First report by me.
85.
Yes. Please come to 85 for a moment, my lord. When you file page 84. 11.4, yes. Page 84, my lord. The applicant has applied for getting mutation in respect of land measuring 3 katha, 10 lecha, covered by so-and-so. The applicant has purchased the said land from earlier recorded Pattadar Subhadra Medi, white registered sale deed. This is the forged deed. Tag number so-and-so matches with the revenue record. During field verification, as the iron gate in front of the applied land was kept closed by lock, measurement of the applied land could not be done, and no information could be gathered as regards possession. The applied land being urban land is free from sealing, but notice it, but it is stated that as per manual record, the name of Bandana Medi stood mutated by way of inheritance in place of Subhadra Medi as per receipt number so-and-so in this office, and as per objection, the application, the objector Dusmanto Medi, that is the nephew, son of Birubhando Medi, has informed about ongoing probate miscase and title suit number so-and-so. As regards the said mutation application, it is necessary to conduct a hearing of the objector. What is the wrong I have committed, my lord? I have said as per the manual record, it is evident that the Pottadar is the one, my lord, that lady's name, my lord.
Bandana Medi.
Bandana. This is my first report. Then second report, which has been taken at page 85. With reference to the above subject and mutation case, it is seen during field inquiry today, Thursday, that land measuring 3 katha 10 lesa covered by so-and-so is surrounded by concrete wall on all 4 sides, and inside it, there is a tin godown room measuring about so-and-so. During field inquiry, it was told that Pradeep Kumar Das, son of late Madan Das, has constructed boundary wall.
This is a different plot of land.
Yes. Now, the last paragraph, my lord. As per records, patta of land measuring so-and-so are covered by so-and-so, and aforesaid Sahar is in the name of Bandana Medi, wife of Surendra Nath Medi. So I have depicted the correct picture. Now, this report was taken note of to be offensive. And my lord, the appointing authority has taken note of this in the impugned order.
information about my relationship.
Yes.
You are
But
still under
if
custody.
this is how disciplinary proceeding are to be conducted, then it will be serious, my lord.
Where is the inquiry report?
Yes. Inquiry report to what is it? Yeah, page 102, my lord. And please come to 107. Para 7 and 8. Whereas as per the first report of Ratneshwar Das, Land Record Assistant Office of the so-and-so, the present status of possession could not be ascertained and measurement could not be done due to lock condition of the iron gate, and that the scheduled plot of land stands in the name of Bandana Medhi, wife of Sri so-and-so. The report also clearly mentions about ongoing so-and-so. And whereas in the second report, Land Revenue Assistant Sri Ratneshwar Das, Gauhati, mentions about a tin godown and a boundary wall, and that both the godown and boundary wall are constructed by Pradeep Kumar. Was it said? I don't think so. It was said. It was not said. That's
No,
not
no,
on the.
that report says.
Anyway.
Second report says that the wall was made by Pradeep Das.
But my lord.
But the land is in the name of
Yes.
Bandana Medhi.
So my lord, where is that portion?
No, where is this charge?
Huh?
Where is
There is
the
charge. There is no charge. And my lord, kindly see the conclusion of the inquiry report, my lord. Based on the thorough examination of all aspects of the departmental proceeding and evidence gathered, it is concluded that the charge of corruption, misconduct, abuse of official position, etc. of so-and-so are substantiated. In view of the findings of the inquiry, I respectively submit that departmental proceeding initiated against Ratneshwar Das by so-and-so have been concluded with recommendation that suitable disciplinary action may be taken.
Mr. Chaudhary, if you
Yes.
can come to page 104. Let's see the procedure followed.
104, Miller. Yes. Following documentary evidence is considered in course of inquiry. Statement of police.
Mr. Chaudhary, the following statements were recorded during the course of the inquiry.
Yes.
That means only Ratneshwar Das's statement was recorded.
Only.
Where is the production of documents, everything?
Nothing.
So how can this be? The documents by itself will not be admissible evidence. It has to be
Unless it is
produced by-
proved. No, well, that's why I said if this is how disciplinary proceeding are conducted, a very wrong
bad state.
precedent would be set, Millard. Supposing a guilty person will also go scot-free.
I found a case the other day.
Huh.
Mr. Kolita's case. No, Mr. K. Kolita's case.
Huh.
I was against him, totally against him. It never occurred to me, I was blushing, never occurred to me that it was not a show cause. I found a show cause. I don't go deep, I read. Found a show cause, I found a, what do you call that, inquiry. It was only when I was dictating the order, finally he pointed out, I dictating the order, it was an explanation column.
Not even a show cause.
Not even a show cause. Now, interesting, Mr. Chaudhary. No, that's not the thing. That's besides the point. There was a claim for some area salaries. So this man had come before this court earlier. This court remanded back, check up whether he wants it, whether he gets in on. In terms of that, the director had constituted a committee for that claim. Now, what the district officer does, he takes that to be the inquiry report in the proceeding and imposes the penalty of dismissal. Totally. The file was this much. So, actually, synopsis we found, yes. How? You have to work in Kamrup, you are working somewhere else. How will that be? I was totally against it. I was shocked. Literally, if that is the level of understanding, God save us.
That's why I said, my lord, in a case where actually punishment is to be inflicted, then they will go scot-free.
Yes. This much only?
Yes, my lord.
Dismissal from service. Yes, madam, you have got the records?
Yes, Lordship.
We'll have you at 2.
2 years, Lordship.
So, Chaudhary, if you have any other matter, you can go. Your junior be here.
My lord.
If something is there, we'll call you back.
My lord.
Madam, just go through 2 things we find.
Lordship.
Mr. Chaudhary is also. One, the show cause,
Yes, Lordship.
no details. It's vague to the core of it. It's a settled position of law.
Lordship.
A delinquent cannot be asked to answer to a vague. He'll not understand what he is to do.
Lordship.
Two, the reports that you have taken, he has given two reports on merits. Both reports says that it is Basanti Medi's land,
Kondona.
Kondona Medi's land, and maybe the possession. In the second report, he says some Das had constructed. Maybe he was trying to project a picture of possession. Maybe. But now tell me, if you go through the inquiry report, kindly go through the records also.
Lordship.
Who were the witnesses appearing for the department? Because I don't find any
Lordship.
reference in the
Lordship.
inquiry.
Lordship.
Have they filed a report? What happened to the criminal case? It's pending.
No charge sheet, Lordship.
Not check. FR has also not been submitted.
Nothing submitted, Lordship. IO has submitted an affidavit.
But তাৰপিছত কি কৈছিলো মই কোনটো ল'ম বুলি কৈছিলো ৰাজধানীটা দিম I'll pass the orders. Yes, there. One, na? Mr. Majumdar, there is a decision of the Honorable Supreme Court now coming.
Lordship.
We'll consider your case under that.
Lordship.
Heard Mr. K. Majumdar, learned counsel for the petitioner. Also heard Mr. P. Naik, learned additional advocate, some appearing for the respondents number 17. This matter was heard earlier and is listed today for delivery of orders. Also, the learned counsel for the petitioner has submitted that in the meanwhile, the Honorable Supreme Court has, in its decision rendered in the and in its decision in the case of Sukendo Bhattacharjee versus State of Assam and others, reported in 2026 INSC 523, directed that master role workers would be entitled to have their services regularized. So the decision of the division bench of this court, which was under challenge in the said case before the Honorable Supreme Court, in the case of State of Assam versus Upendas, reported in 2007 GLR 49, which was in challenge in the said case, to be set aside. We are only directing, we are giving it to you, verify, follow Sukendo, that's all.
Let it be on 16th, my lord. At least similar cases are fixed on 16. If one order is passed, it will be, my lord. 16th of July.
Mr. B. Gogoi, learned counsel appearing for the additional advocate general appearing for the state respondents has submitted that the similar issues, petitions involving similar issues has been directed by this court to be listed on 16/6/2026 and accordingly prays that the present petition be also listed on 16/6/2026. Prayer accepted. Registry to list this matter on 16/6/2026.
16/7.
16/6.
No, 7, after vacation, man.
Six. For admission. Hearing for admission.
Lordship,
My
I
matter-
apologize, Lordship.
No, it's okay, it's okay.
Lordship, my matter may be different from their, that was perhaps for casual employee. I am master work.
Oh, all are there.
All are there.
All. Who need it?
Item 35, Lordship.
Supply doesn't know about delivery. Yes, madam.
Lordship, I went through the record, Lordship. I didn't find Lordships any of the queries, Lordship, even though I'm just submitting the record. Lord.
Mr. Monta, your respondent is here. Comment. Mr. Monta, check up whether they are there. Any statement of that Aminul Islam, the police personnel recorded? No.
Yes, one statement is there, Lordship. I get it, Lordship. I can find for your Lordship. This is regarding arrest only, Lordship, whatever I have seen.
Just mark the relevant statements.
Statement means,
Miss, ma'am,
yes, Lordship.
this is too serious a matter. So casually they are doing it. It gives rise to some apprehension. Don't fill up a post, you don't frame a charge properly.
I also received this type of record for the first time, Lordship.
This is from the office of the Deputy Commissioner.
Deputy Commissioner, Kamrup Metro, Lordship.
You just find that those things out for me.
Aminul Islam, Lordship.
Just mark it, give me the page numbers. Then you need not remain, you can go.
Lordship.
Sir, let us see. I'll go ahead, I have few orders to pass. I'll pass those and then come back. Yes. Mr. Monto, which is the one?
37.
Yes.
But I am tutor principal, my lord.
Hmm.
I got my PhD degree from Singhania University in 2014.
Oh.
15. Now one of the, my lord, the lordship kindly see the which is the hurdle, my lord, but their wrong interpretation of their, my lord, that later I am being suffered.
That subsequent.
My lord. The lordship kindly page 60, my lord. That is a public notice. That is only for the, now, my lord, UPSC cleared that, my lord. That is, the UGC has cleared it, my lord. They have filed an affidavit, they have stated, yes, that is prospective effect only.
They have filed an affidavit.
Affidavit, my lord. Regulated regulation policy. Regulated regulation.
Mr. Montoff
My lord.
accepted that the bar that is created on the university is with prospective effect. But the bar is created because they were not following the norms since before. Now, is the state government not empowered to take a decision that from a university like this, people who come out,
My lord.
we don't want them to be principals in our.
No, your lordship kindly see. They have only because of this, my lord, public notice, they have done it.
But see come to page 62 of this. It's there in the petition.
My lord. Yes, your lordship kindly see that.
The university, now second paragraph of the said above referred public notice, it is clearly stated that 3 universities did not follow the provisions of UGC PhD regulation and also the academic norms for award of PhD degrees. Therefore, due to non-compliance of so-and-so, the PhD degree awarded from the above 3 universities cannot be accepted by the so-and-so for any condition withdrawal for regularization, so-and-so, so-and-so, so-and-so. Now, if the UGC had barred the universities
My lord.
from proceeding with giving of PhD courses,
My lord.
because they were never following the regulations.
No, your lordship kindly subsequent line, my lord. In the RTI application, my lord, and that point of time, it is been followed, my lord. In RTI, page number 82, your lordship kindly see.
82.
82. Our reply, my lord.
No, this is, I got it. But the UGC thing says, without time reference, that all the degrees which have been brought from that, which have been acquired from that university, were so being given without following the norms prescribed. Now, if that be so, why is the state not bound?
In their state filing affidavit, they have stated that because of this or this, because of.
No, they have clarified that in the notice itself. That's what I was trying to get a clarification from you, page 62.
My lord.
This is the office memorandum executive order.
Yes, my lord.
Last paragraph.
In the second paragraph of the.
Also, the university did not follow the provisions. So a university which does not follow the provisions and issues degrees,
My lord.
why is the government not empowered to hold? And
No,
we will,
that-
maybe a valid degree, but we will not hold it for this purpose.
Yes, correct, but they have to get clarification from the UGC, my lord, that point of it is.
No. Their
No,
clarification.
on what basis they will do that?
They say, come after analyzing so-and-so
Analyze.
has found that it did not follow.
But what analyzing, my lord? When university says, my lord, when UGC said, at that point of time it was followed, my lord.
Now, where is that UGC circular to that effect? Finding of the UGC that when you were there, this was being followed.
Because we are gathered this information from their affidavit.
That affidavit in para 8, that is, I think, the UGC affidavit.
60, page 64.
Now you demonstrate that you had acquired this degree. When did you acquire this degree?
2014 and 2016.
2014.
And 2016.
Two petitioners.
Two petitioners.
So show me that it was following the regulations of 2009. Where is the material?
My certificate, that is page 18, my lord.
Certificate will not show. What is behind that certificate? That is what we.
Behind that certificate, that is.
Only Mr. Monto satisfy this court that the award is by following the provisions.
My lord,
Because that is being said to be violated.
My lord, correct. Correct, my lord. I cannot produce all these things because until and unless, my lord, it has to be clarified by the, my lord, UGC, my lord.
No, UGC general. Now it's up to you and the university to come up. Anybody appealing for the Singhania University?
Yes, Lordship, there's a small clarification that I would make. There's this document prior to this public notice. There was a show cause notice dated 23rd October 2024 that was issued by UGC. I have a copy of that. That would clarify certain things. This was prior to this public notice, wherein certain informations were sought. So page two, Lordship. I'll draw Lordship's attention to page 2.
Yes, what do you want to show?
Lordship, in page 2, the middle portion, there are certain pointers which has been highlighted. Para 13. I would read, Lordship, as per the information provided by the university authorities, the university awarded 891 PhD degrees during the year 2016 to 2020. That is the period for which the entire thing has been sought for.
But now that you also show now that you were following this provision of 2009, after 2009 had come into being, that you were following that.
Lordship, for that, Lordship may grant me a time to seek instructions on that aspect.
But what is this manner you're doing here? There is a serious issue with regard to your university. Some people are suffering and you are taking it casually. You have not even cared to file an affidavit in the matter. You're
Lordship,
a party respondent.
Yes, indeed, Lordship.
Why?
Lordship, these certain instructions were awaited from the...
Why this information is not coming through? When the issue is pertaining to your offering of courses.
Lordship, the queries which have been raised...
Mind you, we come to a conclusion that you are not offering the courses in a manner required. We will not keep them hanging. We'll impose heavy cost on you to be paid.
Lordship may grant us days time also.
Yes, my lord. In fact, my lord, that public notice that has been challenged before the Delhi High Court, it was quashed, my lord.
Quashed.
It was quashed.
That is quashed. Singhania University is no longer.
Singhania University is file an application, file a challenge it.
That was quashed. What is the ground?
My lord, I'm judgment. I have not gone through it, my lord. That's not we have given me, my lord. I just read para 71 only, my lord. Others I have not given, my lord.
Your name?
Lordship, T.R. Sen, Lordship.
Okay, we give you an adjournment.
Lordship, deeply.
Subject to payment of 50,000.
Lordship, Lordship, that will be, Lordship, only a day's time.
I'm saying we have passed this order on 29/4 for you to file an affidavit.
Lordship, only a day's time, Lordship, or at least an hour.
50,000.
Lordship, an hour.
Hour will be 20,000. Who are you?
Lordship,
you can take this court for a ride.
No, Lordship, apologies.
These orders are only to be remaining in paper. This order I passed, 29/4. Then the coordinate bench gave a cost of 5,000. Still, you don't have anything.
Lordship, the information has been sought, Lordship.
Information sought. When the money is paid, information will also come. Lekha.
Lordship may grant. Lordship, this is the only opportunity. I'll humbly pray, Lordship.
Okay. Complete instruction, full-fledged by 3 o'clock.
Lordship.
Otherwise, it is 50,000. And we will ensure that it is paid. We will take it up. We want information that 2009 coursework, every particular details you placed by 3 o'clock. Yeah. heard Mr. P.K. Das, learned counsel for the petitioner. Also heard Mr. R.K.D. Chaudhary, learned senior counsel, and DYSGI, assisted by Ms. L. Devi or Ms. B. Sharma, L. Devi for for the respondents. Also, the challenge in the present writ petition by the petitioner is to an order dated 12/10/2011, passed by his disciplinary authority, imposing upon him a penalty of dismissal from service on conclusion of a departmental proceeding instituted against him for having committed a misconduct by remaining unauthorisedly absent. The petitioner has also challenged an order dated 9/5/2017 issued by the appellate authority affirming, rejecting the appeal of the petitioner submitted by the petitioner and thereby affirming the order dated 12/10/2011 passed by the disciplinary authority. Also, at the outset, this court would note the developments taking place in the matter after the institution of the present writ petition. The present writ petition was taken up for final consideration by a coordinate bench of this court and on an due examination of the issues arising in the present writ petition, while judgment and order dated 17/3/2022, the coordinate bench of this court had dismissed the present writ petition. Being aggrieved, the petitioner had had approached the division bench of this court by way of instituting a writ appeal, being writ appeal number 164/2022. The division bench of this court, accepting the submissions made by the petitioner before it, proceeded while order dated judgment and order dated 27/4/2023 to interfere with the decision passed by the coordinate bench of this court, while the judgment and judgment and order dated 17/3/2022 and remanded the matter for a fresh consideration on merits after adverting to the pertinent grounds of challenge laid to the impugned order of dismissal from service based on procedural irregularities as highlighted by the petitioner. Also, accordingly, the matter on being remanded was placed before this court, and the learned counsel for the parties were heard at length on 28/4/2026, and the matter is listed today for delivery of orders. Also, brief facts requisite for adjudication of the issue arising in the present writ petition is noticed as under. Also, the petition while working as a constable general duty with the Central Reserve Police Force, hereinafter referred to as contents, has projected that he had met with an accident on 22/12/2009 while being posted at Delhi. Also, the petitioner was granted 30 days earned leave by the respondent authorities, that is with effect from 6/1/2010 to 4/2/2010, and he was brought to his native village at Nalbari for treatment by his parents. Also, the petitioner not having resumed his services after the lapse of the leave granted to him, the respondent authorities had issued a communication dated 21/2/2010 intimating the petitioner that he had overstayed his leave with effect from 5/2/2010 without permission from the competent authority, and required him to rejoin his services on receipt of the communication with supporting documents, failing which disciplinary action would be initiated against. The said communication is found to have been followed by a further communication on the same lines issued on 6/3/2010 by the authorities of the force. Also, the petitioner contends that he was not in a position to resume his services as he was suffering from mental disorder and was receiving treatment for the said purpose at purpose from the medical and health officer -1, SMK Hospital, Nalbari. Also, the petitioner also projects that the petitioner thereafter contends that he had joined his services on
On 1/7/2011,
on 1/7/2011. Also, the petitioner, after discharging his duties for certain period of time, left his unit without intimation with effect from 14/10/2010. Also, subpara. The petitioner, having absconded from his unit with effect from 14/10/2010, the force authorities appointed an inquiry officer to inquire into the charges framed against the petitioner. Accordingly, the inquiry officer completed his inquiry and submitted his report on 8/9/2011. Oh, sorry.
1990.
A court of inquiry. Sorry. The petitioner not having resumed his services, after remaining absconding from 14/10/2010, an FIR came to be lodged by the force authorities with the SHO, Dwarka Police Station, 6 Sector 16, New Delhi on 15/10/2010. Subsequently, a warrant of arrest was issued to the Superintendent of Police, Nalbari, for apprehension of the petitioner on account of his non-reporting for duties. Also, the petitioner is found to have been neither apprehended by the civil police nor reported for his duties. A court of inquiry was ordered to inquire into the circumstances under which the petitioner had absented from his unit. Also, after completion of the court of inquiry, the petitioner was declared a deserter with effect from 14/10/2010. That is the date of his absence from his unit. So, upon conclusion of the inquiry, court of inquiry, materials having come on record with regard to commission of a misconduct by the petitioner in the matter, a memorandum of charge dated 18/4/2011 came to be issued to the petitioner, and therein the allegation leveled against him was of deserting from his unit with effect from 14/10/2010
till date,
and having remained absconding till the date of issuance of the said memorandum of charge. So, the memorandum of charge is contended to have been received by the petitioner. However, no written statement was so preferred by the petitioner against the said memorandum of charge. Accordingly, a response not being received from the petitioner with regard to the said memorandum of charge issued, comma, the post authorities proceeded to hold an inquiry in the matter. Also, it is projected that the inquiry officer had issued notices to the petitioner for appearing in the inquiry. However, the said notices were not responded to. The inquiry officer thereafter proceeded in the inquiry ex parte and submitted his report on
1999.
19/9/2011. Also, the petitioner has projected that the petitioner, although had received the said notices, on account of the mental ailment suffered by him, he was not in a position to understand the consequence of non-responding to the said notices. Also, it is to be noted herein that the petitioner had appeared before the inquiry officer at the initial stages. However, subsequently he had refrained from appearing before the inquiry officer. Also, the disciplinary authority of the petitioner had forwarded a copy of the. You have been given an inquiry report?
Yes, my lord.
Had been forwarded a copy of the inquiry report to the registered address of the petitioner. However, the petitioner had not responded thereto. Also, accordingly, the disciplinary authority of the petitioner, void order dated
12.
May. What is the date of the order? 9/5.
Yes.
2017. Proceeded to impose. No,
my lord. This is 12th of October 2011. 47.
12/10/2000 page.
47, my lord.
12/10/2011 proceeded to impose upon the petition a penalty of dismissal from service with effect from the date of issue of the said order dated 12/10/2011. Also, the petitioner thereafter submitted an appeal in the matter. However, the appellate authority, void an order dated 9/5/2017, proceeded to reject the same, thereby affirming the penalty of dismissal from service as imposed upon the petitioner by his disciplinary authority, void the order dated 12/10/2011. Also, being aggrieved, next, the petitioner has instituted the present writ petition. Mr. B.K. Das, learned counsel for the petitioner, has fairly, by reiterating the facts noticed herein above, has fairly submitted that the notices in the inquiry proceedings, the notices of the departmental proceeding instituted against the petitioner, including the memorandum of charge, was received by the petitioner. He further submits that the petitioner had also received communications from the inquiry officer for appearing in the inquiry, and he had appeared before the inquiry officer for the purpose. However, the petitioner inquiry for the purpose on 1/7/2011. However, on account of the ailment suffered by him, he had not appeared any further after 19/7/2011. Mr. Das further submits that the copy of the inquiry report was also furnished to the petitioner. However, he had also not responded to the same. Having made the said submissions, Mr. Das has submitted that the reason why the petitioner had not responded to the memorandum of charge and other notices issued to him, including the inquiry report, was on account of the fact that the petitioner at the relevant point of time was suffering from mental disorder and accordingly was not in a position to comprehend the notices as well as the comprehend the memorandum of charge, comprehend the contents of the memorandum of charge, notices as well as the inquiry report forwarded to him. Mr. Das, in support of the submission that the petitioner at the relevant point of time was suffering from mental disorder, has placed reliance on the, where is that certificate?
The medical certificate, one is at 144, my lord.
No,
And
the,
yes, earlier, my lord, page 27, my lord.
has placed reliance on a certificate dated 26/11/2016 issued by the doctors of LGB Regional Institute of Medical Health. And there is one more.
Yes, 144, my lord. And additional affidavit.
And a certificate dated 23/2/2024. That is the one
Yes,
issued by
for the period, my lord.
issued by the medical and health officer, SMK Hospital, Nalbari, certifying therein that the petitioner was under his treatment with effect from 16/10/2010 to 29/6/2011 and 22/7/2011 to 24/10/2011 for the disease So, accordingly, Mr. Das submits, although the absence of the petitioner may be was unauthorized, the same on account of the reasons existing in the matter, which had the effect of restraining the petitioner from resuming his service, cannot be called to be willful and or deliberate. That's your submission.
Moreover, my lord, yesterday I given one list of death, my lord. These grounds may be taken into account, my lord.
Okay.
In the list of the page 3, my lord. And his judgments also I relied, my lord.
We'll only take on crucial. The others are not.
I'll leave it to my lord.
Also, the petitioner, learned counsel for the petitioner has further submitted that the inquiry officer in his inquiry report had also, while holding the inquiry officer in his inquiry report, while holding the absence of the petitioner to be unauthorized, had not held the same to be willful. Also, where is your pleading with regard to this presenting officer in the inquiry? It's not there in the
That is not there.
Then how should we take it up?
But probably, yes.
Why should we take it up?
Correct.
The court said a division bench remanded it
Yes.
in connection with the writ petition only.
Right, my lord. My lord, however, that a witness 1, 2, and 3 said, my lord, that may be reflected.
That
Yes.
will be taken. Also, Mr. Next, Mr. Das, learned counsel for the petitioner, in support of his said submissions, has placed reliance on the decision of the Honorable Supreme Court in the case of Krishnakant B. Parmar versus Union of India and others, reported in 2012, 3 SCC 178. The learned counsel for the petitioner has further submitted that there was no presenting officer appointed in the inquiry, and the inquiry officer had acted both as the presenting officer and the inquiry officer, and accordingly, the entire inquiry stood vitiated. Mr. Das has made a further submission to the effect that the unauthorized absence of the petitioner with effect from 14/10/2010 can be so construed till only 31/36/2011, inasmuch as the petitioner had resumed his services with effect from 1/7/2011. The further unauthorized absence of the petitioner with effect from 19/7/2011 could not have been taken as a part of the same transaction involved starting from 14/10/2010, and a separate charge sheet for the said purpose was required to be so issued to the petitioner. A separate departmental proceeding in this respect ought to have been issued to the petitioner. Mr. Das has submitted that there being no previous history of the petitioner of remaining unauthorisedly absent, the absence of the petitioner treated to be unauthorized by the respondent authorities being on account of the ailment suffered by him, there being a justifiable explanation for the absence, the penalty as imposed upon the could mandate an interference. He submits that even if this court holds that being a member of a had found to have acted in the matter in violation of the discipline mandated to be maintained by a member of a discipline, this court would consider that the penalty of dismissal from service as imposed upon the petitioner is disproportionate to the allegation proved against him in the matter. Mr. R.K.D. Chaudhary, learned counsel for the petitioner, at the outset has submitted that during the inquiry, the petitioner had not furnished any material to demonstrate that he had remained absent for reasons which, for justifying the absence of the petitioner to be based on reasonable grounds. He submits that the plea that the petitioner was suffering from mental ailment was not placed before the inquiry officer. Mr. R.K.D. Chaudhary, learned senior counsel, appearing for the respondent, submits that a perusal of the certificate dated 26/11/2016, issued by the LGBI hospital, brought on record in the petition, would go to show that the petitioner did not suffer from any psychiatric illness during the period the petitioner was under observation in the hospital. Mr. Chaudhary further submits that the said certificate reveals that the petitioner did not go up for any follow-up treatment from 7/11/2011 to 2016, and had also not appeared before the mental hospital, had appeared before the medical board as constituted in the medical hospital. Also, Mr. Chaudhary has submitted that the plea of the petitioner of being suffering from mental ailment not being found to have been supported from any medical document brought on record by him, even in the present petition, and the medical document relied upon by the petitioner having demonstrated that the petitioner at the relevant point of time to be not suffering from any mental ailment, the claim of the petitioner that the absence was not willful would not mandate an acceptance by this court. Mr. Chaudhary submits that the petitioner was given all due opportunity, the departmental proceedings instituted against him. However, he had refrained from utilizing the same. He submits that although the petitioner for a short period had appeared before the inquiry officer, however, he had continued with his unauthorized absence Also, Mr. Chaudhary next submits that the petitioner before the division bench of this court had relied on the Honorable Supreme Court in the case of Krushant P. Parmar Supra for the proposition that in a departmental proceeding, a departmental proceeding involving an allegation of misconduct of the remaining unauthorizedly absent, the inquiry officer is required to record a finding that the unauthorized absence of the delinquent was also willful and deliberate. He submits that the decision of the Honorable Supreme Court in Kurshan B. Parma was considered by the Supreme Court subsequently in its decision in the case of Chennai Metropolitan Water Supply and Sewerage Board and others versus T.T. Murli Babu, and had concluded that the decision of the Honorable Supreme Court in the case of Kurshan B. Parmar has to be restricted to the facts of the said case, regard being had to the rule position, the nature of charge level against the employee, and the material that had come on record during the inquiry. He submits that the Honorable Supreme Court had further held that it cannot be stated as an absolute proposition in law that whenever there is a long unauthorized absence, it is obligatory on the part of the disciplining authority to record a finding that the said absence is willful, even if the employee fails to show the compelling circumstances to remain absent. So accordingly, in the next, in the above premises, Mr. Chaudhary submits that the penalty of dismissal from service imposed upon the petitioner by the order dated 12/10/2011, not mandate and court. I've heard the learned counsel for the parties and also perused the materials. At the outset, this court would notice the decision of the division bench of this court rendered in an appeal instituted by the petitioner after the present writ petition was dismissed by judgment and order dated 17/3/2022 to Court Crucial Report 17/3/2022 by coordinate bench by judgment and order dated 17/3/2022. The division bench of this court had wide judgment and order dated 27/4/2023 disposed of the said writ appeal by directive as follows. Para 9, that is a green flag. No? A perusal of the decision of the division bench as noticed herein above would go to reveal that the division bench had noticed that there was an inherent lack of phraseology, right, apostrophe between willful absence, apostrophe over, in the article of charges as well as the order imposing penalty. The court further went on to hold notice the averments made by the petitioner in paragraph 17 of the writ petition and found that although the said argument was raised before the learned single judge, in the judgment and order dated 17/3/2022, the same, although noticed in paragraph 14, comma, a contradictory finding was recorded in para 14. Also, accordingly, the judgment and order dated 17/3/2022 passed by the coordinate bench in the present writ petition was set aside and was reversed and the matter remanded to this court. The division bench having required the consideration of the present present writ petition basing on the grounds of challenge as raised by the pertinent grounds of challenge as raised by the petitioner in the writ petition, more particularly paragraph 17 thereof, comma, this court would now proceed to consider the issues arising in the present writ petition by keeping in view the directions passed by the division bench of this court and noticed herein above. Also, it is admitted by the learned counsel for the petitioner as well as by the learned counsel for the petitioner that the absence of the petitioner with effect from 14/10/2010 was unauthorized. The further pleas taken by the learned counsel for the petitioner is that although the said absence was unauthorized, comma, the charge sheet not having alleged the same to be willful and also the respondent authorities having not, the inquiry officer in the inquiry report also having not found the absence to be willful, and the disciplinary authority in its order dated 12/10/2011 also not having held the unauthorized absence to be willful, comma, the unauthorized absence would not mandate, the unauthorized absence of the petitioner would not have mandated imposition of a penalty of dismissal from service upon him. The further submission of the petitioner is that he being suffering from mental ailment during the period in question and was being under treatment, comma, there being a justifiable reason adduced by the petitioner for having remained unauthorizedly absent, comma, the period of absence of the petitioner with effect from 14/10/2010 under no circumstances could have been treated to have been to be unauthorized. Also, the other facts, the petitioner's learned counsel for the petitioner having admitted that the period of absence of the petitioner was unauthorized, this court does not proceed further to examine the conclusions drawn by the inquiry officer as well as by the disciplinary authority in the inquiry report and in the order dated 12/10/2011 respectively. This court would now consider the challenge made, consider the submissions of the learned counsel for the petitioner that in absence of a finding that in the departmental proceeding that the absence was willful, comma, the same was not permissible to be so treated for imposition of any penalty. In paragraph 17 of the writ petition, the petitioner had raised contentions in this connection. So, the basis for the submission made by the petitioner is the decision. The petitioner has based the said submissions on the decision of the Honorable Supreme Court in the case of Khushwant v. Parma Supra. However, this court finds that the said decision in the case of Khushwant v. Parma was considered by the Honorable Supreme Court in its decision held in its decision in the case of Chennai Metropolitan Water Supply and Sewerage Board, bracket Supra. The conclusions are drawn by the relevant conclusions of the Honorable Supreme Court in this connection is extracted here in below. Para 22, 3, to 23. So, the Honorable Supreme Court, having on consideration of the decision rendered by it in the case of Kushwant B. Parmar, having restricted the same to the facts of the said case, regard being had to the rule position, nature of charge level against the employee and the material that had come on record during the inquiry, this court finds that the decision of the Honorable Supreme Court in Kushwant B. Parmar, bracket Supra, would not advance the case of the petitioner. Also, accordingly, there being a clear admission that the petitioner's absence was unauthorized and the same being reiterated before this court in the present proceedings by the learned counsel for the petitioner, this court holds that the absence of the petitioner with effect from 14/10/2010 was admittedly unauthorized. The petitioner being a member of a disciplined force, accordingly is held to have committed a misconduct in the matter. Also, having drawn the said conclusion, this court would now further examine the further submission made by the learned counsel for the petitioner that the period of absence of the petitioner with effect from 14/10/2010 cannot be held to be unauthorized in as much as a justification was available in the matter on the part of the petitioner to the effect that he was during the set period of absence receiving treatment for the mental ailments suffered by him. In support of the said submissions, the petitioner had relied on two medical opinions rendered in the matter. One by the doctors of the LGB hospital, mental hospital. LGB
Regional Institute.
LGB Regional Institute of Mental Health. And further, a medical certificate issued by Dr. Gautam Nath, Medical and Health Officer -1 SMK Hospital, Nalbari, Assam. This court has perused the certificate, certificate given to the petitioner by the authorities of the LGBI hospital. On a perusal of the said certificate, this court finds that the doctors in the said hospital, on an examination of the petitioner, where is that certificate, Mr. Das?
Yes, that certificate is
on an examination of the petitioner had highlighted that the petitioner was admitted in the institute on 28/10/2011 for diagnosis and treatment, and he was discharged, on his own request, on 7/11/2011. It was further highlighted that on evaluation, no psychiatric illness was found during the period of his observation. Also, it was further highlighted in the certificate that following discharge, he had not come back to the institute for any follow-up till 26/3/2016, and on 26/3/2016, he had attended the OPD for a medical certificate and was then advised to attend the next medical board, which he, however, did not attend. The petitioner's certificate is originally dated 26/3/2016. However, he, having lost the said certificate, had made an application before the authorities of the LGB Regional Institute of Mental Health for issuance of a duplicate certificate. Had submitted a RTI application in this connection, and it is as a result thereof that the certificate dated 26/11/2016 was issued to the petitioner. On a perusal of the said certificate, it would be clear that the petitioner was not suffering from any psychiatric illness. Mental disorder does not occasion on a single day. It's a gradual process, and the same cannot also be held to have been cured immediately after its onset. In the event the petitioner, as on 14/10/2010, was suffering from any mental ailment, the experts at the LGBRI Institute of Mental Health would have detected the same by considering the conduct of the petitioner during his examination. The experts, having held that the petitioner was not found to be suffering from any psychiatric illness, the plea taken by the petitioner in the present proceedings for evading present proceedings of suffering from mental disorder is found by this court to have been so taken only to evade the proceedings instituted against him, disciplinary proceedings and for the purpose of assailing the orders passed therein, and for assailing the penalty. There is not even a single document brought on record which would conclusively establish that the petitioner during the period he had remained absent, that is with effect from 14/10/2010, was suffering from mental ailment. The contention of the petitioner that he was not in a position to respond to the memorandum of charges and other notices issued to him during the departmental proceedings, during the conduct of the departmental proceedings instituted against him, is found to be false. The petitioner not being suffering from any mental disorder as certified by the medical officers examining him at his own instance, the non-response to the given to the by the petitioner to the notices issued to him in the departmental proceeding is found by this court to be deliberate and willful. Also, the other medical certificate relied upon by the petitioner is dated 23/2/2024. The doctor issuing the said certificate had certified therein that the petitioner was under his treatment for the period 16/10/2010 to 29/6/2011, and from 22/7/2011 to 24/10/2011 for disease of suffer from his head injury of for the disease of suffer from his head injury and extracranial hematoma in temporal region. The doctor issuing the said certificate is found to be a general medicine practitioner and not a specialist for dealing with problems arising from head injuries, and that too to the extent what has been certified in the said certificate. The said certificate on the face of it would not advance the case of the petitioner. At this stage, it is to be also noted that the certificates issued by the authorities of the LGBRI hospital, as well as the said certificate dated 23/2/2024 were never produced before the inquiry officer. So, in view of the above position, this court finds that the petitioner had deliberately remained away from his duties and for the purpose of and had taken up a false plea of being suffering from mental disorder, while the medical documents produced that does not justify the said contention raised by the petitioner. Also, it is a settled position of law that unauthorized absence is an act of indiscipline. Whenever there is an unauthorized absence by an employee, two courses are open to the employer. Also, the first is to condone the unauthorized absence by accepting the explanation and sanctioning leave for the period of the unauthorized absence, in which even the misconduct would stand condoned. The second is to treat the unauthorized absence as a misconduct, hold an inquiry, and impose a punishment for the misconduct. Given the materials coming on record, the petitioner not having brought before the respondent authorities any cogent material basing on which a decision with regard to the condonation of the unauthorized absence could have been taken by the respondent authorities, the respondent authorities treating the period of unauthorized absence of the petitioner to be a misconduct is found justified by this court. This court further holds that the unauthorized absence of the petitioner not being justified by him by adducing cogent material, even in the present repetition, the penalty as imposed upon the petitioner in the considered view of this court would not mandate an interference. Also, accordingly, this court is of the considered view that the penalty of dismissal from service as imposed upon would mandate to be affirmed. The petitioner, learned counsel for the petitioner, at this the learned counsel for the petitioner had made a submission to the effect that the penalty as imposed upon him in the departmental proceedings by the order dated 12/10/2011 was disproportionate to the allegations leveled against him, the allegations established against him in the inquiry. In this connection, this court would rely on would again refer to the decision of the Honorable Supreme Court in Chennai Metropolitan Water Supply and Sewerage Board (Supra), The Honorable Supreme Court in this connection, in the said decision, had drawn the following conclusions. Para 28 of RA, 29, 30. Ra, 31, 32, 33. 33. So, applying the said decision of the Honorable Supreme Court in the case of so-and-so to the facts of the present case, this court is of the considered view that the penalty as imposed upon the petition by a penalty of dismissal from service imposed upon the petition dated 12/10/2011 is found to be justified and proportionate to the allegations leveled against him. More so when the petitioner is a member of a disciplined force. So in view of the above discussion, the present writ petition is found to be devoid of any merit, and accordingly the same stands dismissed. However, there would be no order as to this. Sorry, Mr.
It's okay, my lord. Obliged, my lord. It's-
Yeah. Yes, Ms. Baksaji.
Lordship, I have gone through this, Lordship. I think no statement has been recorded, Lordship. What is was the written statement and one yellow flag, Lordship, where Aminul Islam's this written submission has been taken as in the second page. It is written, Lordship. It is recorded as statement, Lordship, something like this. And from the note sheet also nothing revealed, Lordship, regarding.
Where is Aminul's statement of Aminul?
Yes, Lordship.
Oh,
Yes, these things, Lordship.
pathetic.
I have seen flaws, Lordship, but not like this. This is the first time, Lordship.
মঙ্গলবারে ডেলিভারি ফটো কিটা আছে আৰু আছে নেকি মঙ্গলবাৰ লগাই Very faithfully. But the learned counsel for the parties are some length. Hearing remains inconclusive. Registry to list this matter again on Tuesday as a part-heard item. Just make a mention in the morning. There are two pre-orders to be passed. I'll pass this as the fourth. And madam, you keep this. And if possible, if you get time, just make a index and give it to me.
Lordship.
That day, so I've received, so
Lordship.
I can just.
Okay, Lordship. I shall.
Obliged, Lord.
Deeply obliged, Lordship.
Yes, Mr. Sen.
Lordship, I have sought for the instructions, however, Lordship, but humbly state this entire query. This query is something which was never the point of discussion beforehand.
I mean, that is the basis of the writ petition.
Lordship,
That is the
pri-
allegation.
The prior, whatever, Lordship, the period, Lordship, here the aspect is about the period which is from 2016 to 2022.
You
that-
show me how did you do it in 2009? Because the government says that we are apprehensive that you have followed it. I'm not using very other words, but the government seems to be apprehensive. Now you show that you had done it properly in 2009. And why, in spite of passing orders, you are some superior authority?
Lordship,
Huh?
this topic, the
You
entire,
get the whole records of 2009 here by Monday morning.
Lordship,
Entire records.
Lordship, it's,
From wherever you are. Or we'll ask the deputy commissioner or the commissioner of police here to go and arrest you. What is this? Taking this court for a ride?
Lordship, I sincerely apologize because of this entire scenario. However, Lordship, the period which was in question was something which now the period of 2009 was never a topic in the writ petition. That was something which we couldn't apprehend, and that is the
He gets his certificate in 2009. You can't apprehend.
14.
You are running a university.
14, Lordship.
No, 14. I get 14.
2014.
I don't want 9. Get 14.
2014 and
14
2016.
and 16. 14 and 16. 2009
In
I said
respect-
because of the regulation.
In respect
Yes, it
of
started from 2009.
2009 it started.
the university started in that awarding the degrees in that particular period. However, we in regard to 2014 and 2016, that was the entire case of the petitioner. Should give us an opportunity to file it.
Mr. Sen, you are a very young counsel. I don't want to be harsh with you.
Lordship,
You are getting away because of that. If some senior was there, if Mr. Monto was this side, today it would have been 50,000. Please don't act like this. If your client is not responding, leave that brief. You have a long way to go. We will get hold of your client. Don't worry about it. We know how to get him. Mr. T.R. Sen, at the outset, seeks apology from this court as he was not in a position to complete his instructions. Mr. Sen submits that by the next date of listing, he shall have the affidavit of the respondent represented by him on record, and therein bring on record all requisite materials to demonstrate as to the manner in which the award of PhD degree to the petitioner was so done in strict compliance with the provisions, compliance of the provisions of the, what was that?
UGC norms.
Two 2009 order of regulation, the UGC regulation. Mr. Monta, where do I get that name?
UGC office 17 April 2009. UGC as per requirement of UGC Act 1956, my lord.
No.
Page 31, page 29.
20?
29, UGC agree. Page 29.
Terms of the UGC bracket minimum standards and procedure for awards of MPhil, M.Phil nowadays.
Regulation 2009.
PhD, PH.D degree regulation 2009.
And 33 page 2016 also.
And the set and the page 30?
33.
30?
33 page number. Another notification that is 2016.
And the AK regulation 2000.
Only 2016. Yes.
16, huh?
19 and 9 and 16.
9 and 16. As Mr. Sen had sought apology in the matter, and considering the length of his practice, this court at this stage refrains from passing any adverse orders as well as imposition of a cost upon the respondent, with the expectation that on the next date of listing, the compliance of the directions passed by this court today would the undertaking given by Mr. Sen shall be complied with. Registry to list this matter again on 16 after the vacation, before vacation.
There are similar other 4 petitions are pending in this same point. 25. Those are fixed on 25th.
25th. Oh, before the vacation, you want to hear us such heavy matters?
No, at least,
Oh, this is bad.
at least he will
This
find
is, you also there. Then it will be after vacation only.
He has to read petition, my lord.
On 25.
Yes,
Young
my-
man, I
yes,
don't
my
want
lord.
to go against him.
25, my lord, if I pay for a hearing,
Ah.
then my lord, other advocate will rebuke me, my lord.
25/6/2026. You get your affidavit.
525.
Lordship, if
Nothing more. Please don't make any further submissions. You're a young guy, I've left you.
deeply obliged.
Deep level.
Yeah, 50. Mr. Bothakur, Mr. Dotto. I'll take some more time. I have to dictate one. Aru ki paas nahi hai. Abhi sir 227 ase na. I have
Lord,
some matters.
Lord, I'm sorry, my lord.
It's
I
okay, it's
beg apology because
It's been an experience now, and
I-
thanks. I'm having very good evening off from yesterday. Not touched a single file. Why should I read?
no,
If the advocates are not interested,
we are
to matter.
absolutely
No,
sorry
I'm
for-
thankful to the bar. I'm thankful to the bar. And from today onwards, I'm not reading anything. I'll come here, take up one matter, hear the matter the whole day, pass my orders.
Your lordship culture is that always your lordships come ready. We are sorry that we are not helping.
No. It's not Mr. Doctor only. I can't understand 20 matters, 18 matters called. None there. We don't have that much courts for 18 advocates to be engaged at the same time.
Very, very true.
And it's only around 2.5 years that I've come this side. So I know that.
Yes.
Let me get a little bit more this side so I forget all those.
Your
So this
lordship
place
was
can be taken.
very busy when this side also.
No. I know when I'm not busy also how to tell the court I'm busy. Today will not be possible. We'll have the matters after the vacations. She'll give the dates.
Sorry, my lord.
No, it's okay.
Apologize for that.
I took it out. It'll not there. Today it's not there with me. Yesterday it was there. Yesterday I felt a little bit bad.
Yes.
Yesterday night I could not read it. I was really depressed. Today I'm not. Today I'm okay.
My junior told me.
Today I'm
I
okay.
said okay.
Today I'm okay. So I come reading, I come with a sequence. If that gets constantly being breaked.
In my case, what happened, my lord? I have a first item there in another food.
1-2 persons having this problem. I've never till today I've never said. But day before yesterday and yesterday, everybody is having a problem. No government advocate, none. Everybody is having it. Then I thought, do we have so many courts to accommodate so many advocates at one go? Then I remembered my practice this. Then I thought, okay, this is the reason.
The lordship has the tons of experience this side as well.
Mr. Whenever you want a date, ask her.
Hello.
Ask your juniors, she'll give the date. Date didiba. Jor entry order ase, dekhiloba, entry order extend koriba.
Publish.
Oh. Mata. Huh? Yes, Mr. What have you got? Any further argument required?
My lord, if I have done some.
Please. I'm waiting for that.
My lord, can it be, my lord, we are preparing a rejoinder affidavit, my lord, putting some records, my lord. And if my lordship allows, my lord, then only I will pray, my lord. If not, my lord, then I have to.
I have got my. This is the
All diary, my lord. It appears to be a dangerous matter.
No. This is the land records manual.
I know, my lord,
From this, the connection to the settlement training.
That's correct, my lord. My lord, the only thing is that.
Okay.
My lord.
Mr. A.R. Bhuiya, Learned Counsel for the petitioner, submits that he is examining the issue. Learned Senior Counsel is examining the issue and prays that he be granted further. He be granted some time to come up before this court with regard to the issue, to make his some time to make his submissions with regard to the issues issues raised in the present petition and the objections raised by the Learned Counsel for the respondents. Pray accepted. Registry to list this matter again on 21/7/2026. No further adjournment shall be granted. in the matter 21-7 for further hearing.
Further hearing.
21-7.
21-7.
Lordship.
Let Mr. We don't want.
My lord,
Have you got some idea?
my lord, I have also found few judgments, my lord, that those judgments says that if the reservation rule was there, if it is not notified in the advertisement, then what will be the fate, my lord?
The scheme of the act should be seen. The scheme of the recruitment. It is
Right.
there. There are decisions also. We'll see. Yes, Mr. Das. I don't like seniors sitting in my court for a long time.
There is one urgent matter, my lord. Item
Urgent?
number,
Which matter of yours is not urgent?
no, this is really urgent, my lord.
Oh.
I'm not saying about
Which
the
is,
others.
which is the one?
Item number 44, my lord.
44.
This is that matter wherein the petitioner candidature was sought to be cancelled because he did not get NOC from railway. Then in oil, my lord.
There are some interim orders operating here.
No, my candidature was protected, but after that, my lord, the railway rejected. There was an interim order passed by this honorable court to consider my application.
There was a writ appeal also.
Yes, writ petition, my lord. Then my
Against
NOC
cat order.
cat order. My NOC was rejected. That I challenged before the tribunal. Tribunal allowed it. Then, my lord, the railway filed writ petition before the High Court. Writ petition was dismissed. Finally, I was released by the railway after the dismissal of the writ petition. Now, the thing that has boiled down now is that, my lord, since the writ petition, there was protection of my candidature. Now, a direction I need in the writ petition to the oil authorities to appoint me, my lord. Because I have already been selected.
Lordship, we have relieved from him some service, your lordship.
The railway has
No,
relieved.
Why not appointed?
Lordship, we have received our parawise comments.
Forget your parents' comments. Why appointment is not effective? The appointment was hanging only because the railways did not give their NOC.
Yes.
Proceedings before this court. The candidature is protected. You can't make a further appointment. Why the appointment is not being done?
That's regard, Lordship. My senior was supposed to appear.
You
Lordship.
forget your senior. You are here. We know only you.
As
Who
the
is
matter-
your senior?
K. Kalita, Lordship.
A. Kolita. He's a very busy lawyer.
He's there in the court only, Lordship.
He's very busy. You tell me why. Complete your instructions. Get the matter resolved. We will take it up on 18th.
Yes, Lordship. In the meantime, we'll file our.
Oh no, 18th, not 18th. 17th.
17.
17th will be too early.
Plus 7.
22nd. 22nd.
20.
As prayed for by the Learned Council, 40 parties are registered to list this matter again on 22/7/2026. The Learned Council appearing for the state, Learned Standing Council, IOC, shall complete his instructions as to why the petitioner has not been given his appointment in pursuance to his selection against the post involved in the present petition. Also, registered to list this matter again on 22/7/2026, 22/6/2026. Any interim order to be extended?
My lord, interim order.
Not read,
extended,
huh?
No, it has to be extended. My
The
candidate
interim order passed earlier to be, shall stand extended till the next date of listing. Okay.
also will keep it as a further hearing because nothing more left, my lord. This is the only point, my lord.
If it comes back to me, I am here.
Fine.
So standing council oil, Lordship. We have-
Standing council oil, everything is same, everything is oil only. ONGC, oil, IOCL, all oil.
All are there.
But Mr. B. M. Deca, Learned Council for the petitioner. Also heard Mr. K. Learned Additional Advocate General appearing for the state respondents. For all the respondents, for the respondents number 1, 2, 3, 5, and 6. And Mr. B. Sharma, Learned Standing Council, Accountant General, bracketed A&E. Mr. B. Sharma, always Standing Council. Yeah, pretty fun. Always Standing Council.
That's my privilege.
No speaking council. Really give it there. গরম লাগছে
Madam Govinda Negi.
The petition by way of instituting the present writ petition to agot to toil by instituting the present writ petition has presented a challenge to the institution of a departmental proceeding against him, has prayed for a stay of the departmental proceeding instituted against him till the disposal of the criminal proceedings instituted against him on the same set of allegations. The petitioner has also presented a challenge to an order dated 16/2/2025, placing him under suspension in pursuance to his arrest in connection with the criminal proceedings so instituted against him. Full stop. The facts in brief requisite for adjudication of the issue arising in the present writ petition is noticed as under. The petitioner was initially appointed as a junior engineer in the Panchayat and Rural Development Department and posted in the said capacity to Jugijan Development Block, Nagaon. Thereafter, the petitioner was promoted to the post of assistant engineer with effect from 5/5/2021. The petitioner, while working as an assistant engineer, while order dated 12/3/2024 was transferred and posted as assistant engineer to Central Jorhat Development Block, Jorhat. While the petitioner was serving at Jorhat, an FIR came to be lodged against him on 5/2/2025, alleging that he had demanded a bribe from the informant for release of the informant's contractual dues. Also, the said FIR on being received, by the by the ACB police station, the same was registered as ACB. A GD entry came to be made in the matter. Also, thereafter, a trap was laid and the petitioner, after receiving the demanded bribe amount from the informant, was arrested. Also, accordingly, ACB PS case number 12/2025 came to be registered against the petitioner under section 7(a) of the Prevention of Corruption Act, 1988, as amended in 2018 (over). The petitioner, after being the petitioner was thereafter, petitioner on he being arrested was produced before the trial court and was remanded to 3 days police custody. Thereafter, he was remanded to judicial custody. Also, the petitioner thereafter submitted an application before the trial court for being enlarged on bail. The trial court, considering the materials coming on record as well as the length of detention already undergone by the petitioner, proceeded with order dated 18/3/2025 to enlarge the petitioner on bail. Subpara. In the meanwhile, the additional chief secretary, Government of Assam, Panchayat and Rural Development Department, void an order dated 16/2/2025, invoking the provisions of Rule 6(1) bracketed 1 of the Assam Services bracket Discipline and Appeal bracket over Rules 1964, proceeded to place the petitioner under suspension with effect from 5/2/2025. Also, the petitioner, on being released from judicial custody, not being released his subsistence allowance, had approached the responding authorities by way of submission of a representation dated 29/5/2025, praying for being authorized his due subsistence allowance. Also, the respondent authorities thereafter, while a show cause notice dated 9/6/2025, instituted a departmental proceeding against the petitioner herein. Also, the petitioner submitted his show cause reply to the said show cause notice, on 21/6/2025. The continuation of the prolonged suspension occasioning in the matter. Afusa, it is in the above background that the petitioner had instituted the present writ petition, praying for the reliefs noticed herein above. Also, Mr. P.M. Deka, learned counsel for the petitioner, by reiterating the facts noticed herein above, has submitted that the petitioner, on being placed under suspension, by the order dated 16/2/2025, the respondents had not carried out a review thereof. He submits that the show cause notice having been issued on 9/6/2025, the show cause notice instituting a departmental proceeding against the petitioner having been issued to the petitioner only on 9/6/2025. Admittedly, the same was issued beyond 4 months with effect from the date the petitioner was placed under suspension. Mr. Deka has further submitted that after the issuance of the show cause notice dated 9/6/2025, the respondent authorities have not passed any order, had not served upon the petitioner any reasoned order passed after considering the necessity to extend the period of suspension of the petitioner after the departmental proceeding was instituted against him. So, Mr. Deka has further submitted that the disciplinary proceeding now instituted against the petitioner, while the said show cause notice dated so and so, is based on the allegations leveled against the petitioner leading to his arrest in the criminal proceeding so instituted and presently pending in ACB PS case number 12/2025 and presently pending investigation in ACB PS case number 20. He submits that in the event the disciplinary proceeding is permitted to be taken to its logical conclusion, the defense of the petitioner in the criminal proceedings would stand impaired. Accordingly, he submits that a prejudice being likely to be caused to the petitioner in the criminal proceedings instituted against him, this court would be pleased to stay the disciplinary proceedings till conclusion of the trial in the criminal proceedings instituted against the petitioner. That much only. So Mr. Dekka has, in support of the submissions made by him with regard to the prolonged submission, the suspension undergone by him, has relied upon the decision of the Honorable Supreme Court in the case of Union of India. Ajay Kumar Chaudhary versus Union of India and another, reported in 2015, 7 SCC. Per contra, Mr. P. Kwon, learned additional advocate general appearing for the learned additional advocate general appearing for the respondent number 1, 2, 3, 5 and 6 has submitted that the petitioner on being placed under arrest and the information being received by the departmental authorities, the petitioner was while order dated 16/2/2025 placed under suspension with effect from 5/2/2025, that is the date of his arrest. It is submitted that the petitioner was authorized his subsistence allowances in the matter. You're getting your subsistence allowance?
Not from August to March, my lord. August 2025 to March 2026.
Rest
They have paid, my lord.
he submits that August to
August 2025 to March 2026, my lord.
and April onwards you're getting.
Yes.
Mr. Kumar submits that the respondent authorities prior to issuance of the show cause notice dated (9/6/2025) to the petitioner had extended the period of suspension of the petitioner first extension is 5/6.
5/6.
Page.
It's in their affidavit, page 66.
By issuance of a notification with the 5/6/2025 on a review of the same being so carried out. The said suspension was for the continuation of the suspension was for the period with effect from 6/5/2025 to 3/8/2025. Mr. Kumar submits that the show cause notice having been so issued to the petitioner during the period during the currency of the suspension order, a further order for extension of the period of suspension after the issuance of the show cause notice was not called for. Mr. Kumar submits that the period of suspension was thereafter being extended from time to time. He submits that in the event there is any arrears of subsistence allowance receivable by the petitioner, the same would be processed and released to the petitioner by the respondent authorities at the end. With regard to the so accordingly, Mr. Kumar submits that given the nature of the allegations leveled against the petitioner in the departmental proceeding instituted against him, this court would be pleased not to revoke the suspension of the petitioner and permit the petitioners to conclude the departmental proceeding so instituted also. With regard to the prayer of the petitioner to keep the departmental proceedings instituted against him under stay till the conclusion of the criminal trial, Mr. Kaur has submitted that the criminal proceedings instituted against the petitioner pending in SCB PS case number 12/2025 is still at the stage of investigation And even a prosecution sanction to prosecute the petitioner has not been sought for from the investigating authority, from the investigating agency. Also, he submits that the trial of the criminal proceedings not having been started, no prejudice can be said to be caused to the petitioner in the even the departmental proceeding is taken forward and concluded. He submits that the prayer of the petitioner for stay of the departmental proceeding, in view of the fact that the criminal proceedings institute is still pending at the investigation stage, would not mandate an acceptance from. I have heard the learned counsel for the parties and also perused the materials available. This court would, at the first instance, consider the prayer of the petitioner for a stay of the departmental proceedings instituted against him pending completion, pending conclusion of the trial in the criminal proceedings instituted. Although it is projected that both the criminal case as well as the departmental proceedings are based on the same set of allegations, this court finds that in the criminal proceeding, the same is still pending at the investigation stage. No charge sheet has been filed till date against the petitioner. At this stage, it cannot be presumed that the investigating agency would be filing a charge sheet against the petitioner in the matter and or the nature of allegations that be involved, that would be incorporated therein by the investigating agency. Considering the FIR as well as the forwarding report and other connected materials brought on record pertaining to the departmental proceeding, although this court finds that the allegations both in the departmental proceeding as well as the criminal trial, the criminal proceedings may be the same, may be similar, it is not found that a complicated question of law also arises given the nature of the allegations, in the criminal proceedings instituted against. Accordingly, the purport and intent of a departmental proceeding and a criminal proceeding being different, the criminal proceedings instituted against the petitioner being still pending at the investigation stage, this court is of the considered view that no prejudice would be caused to the petitioner in view of the above facts. In the event the disciplinary proceeding is permitted to be taken to its logical conclusion by the disciplinary authority of the petitioner. Accordingly, the said prayer of the petitioner for a stay of the disciplinary proceedings stands rejected. Also, as noticed herein above, the petitioner was while order dated 16/2/2025 placed under suspension with effect from 5/2/2025. A perusal of the order dated 16/2/2025 reveals that the authority issuing the order had invoked the provisions of Section 6(1) of the Assam Services (Discipline and Appeal) (Overrules 1964). But the suspension of the petitioner was on the ground that he was placed under arrest, and the same was effected with retrospective effect, that is, with effect from 5/2/2025, that is the date of arrest of the petitioner. This court, on a consideration of the contentions made in the said order dated 16/2/2025, is of the considered view that the same was actually passed under section 6(2) of the rules of 1964, and on account of a error, typographical error, in the order, the provision came to be reflected as Rule 6(1) of the rules of 1964. A wrong quoting of a provision. It is a settled position of law. A wrong quoting of a provision in an order would not invalidate that order. Accordingly, this court would proceed to consider the challenge of the petitioner to the order dated 16/2/2025 by reckoning that the same was so issued under section 6(2) of the Act of 1964. As noticed herein above, after being placed under suspension with effect from 16/2/2025, on the date the order of suspension dated 16/2/2025 was so passed, the petitioner was in detention in connection with ACB PS case number 12/2025. He was released from the said detention. He was enlarged on bail in connection with the said, in connection of his arrest in ACB PS case number 12/2025 by the learned trial court wide order dated 18/3/2025. As held by this court in the case of Rafet Ali Ahmed versus State of Assam and others, reported in 2023 GLT 718, the period of 90 days during which during which a suspension would be in currency in terms of the decision of the Honorable Supreme Court in the case of Ajay Kumar Chaudhary Supra, in respect of a deemed suspension under section 6(2) of the rules of 1964, would have to be construed from the date the delinquent, on being enlarged on bail, had intimated his employer about his such enlargement on bail. No material has been brought on record by the petitioner that he had informed the respondent authorities about his enlargement on bail by the trial court by the order dated 18/3/2025. However, the said aspect of the matter would not be material, even the material for adjudication of the issue arising in the present writ petition, given the fact that the respondent authorities on their own had issued a show cause notice to the petitioner on 9/6/22. Accordingly, the show cause notice issued to the petitioner was so issued within a period of 3 months from the date the petitioner had superannuated from his petitioner was released from custody on being enlarged on bail by the respondent, by the learned trial court. Also. কাগজটা বলবো না ওকে। The decision of the Honorable Supreme Court in Ajay Kumar Chaudhary would also apply to a deemed suspension occasioning on the delinquent being placed under arrest and having remained under detention for more than 48 hours. So, the maximum period for which order of suspension can remain in currency has been dealt with by the Honorable Supreme Court in the case of Ajay Kumar Chaudhary Supra. The relevant conclusion of the Honorable Supreme Court in this connection is extracted here in below. Para 20, 21, 22, para 13, so upor to ekhini moi di disu to 14 to mari. 14, 15, 16, এইটো কাটি দিওঁ এই যে লাষ্টত 10, 11, 12, খালি এটা লিখিবি এই যে applicable Ajay Chaudhary is also applicable 6-2 তাতে a para 10 to তাতে 12, 13, 14, 15, 16, 17, 18, 19, খালি suspension order date to বদলাই 20, 21, 22, 23. Disposed of. You will be transferred from Dhubri to Khodia wherever they want.
That's all. I'm grateful, man.
Mr. Ghosh, send him from Dhubri to Khodia. You get up in the morning, point a place, send him there. Para 21, I have provided for that.
For payment of subsistence allowance, we have already issued the pay slips, man.
No. The period. Oh. Hey, disposal of as the counsel for the petitioner had submitted that the petitioner had not been released his subsistence allowance for the period March 2025 to April.
No, my lord, from August 2025 to March
August
2026.
2025 to
March
March
2026.
2026. The respondent authorities shall consider the said position, set submission, set grievance of the petitioner, and in the event the subsistence allowance for the petitioner for the set period is not so released to him, the respondent authorities shall process the same and release the areas of the subsistence allowance to the petitioner within a period of 1 month from the date of receipt of a certified copy of this order.
We have already issued the pay slip.
Money is not coming.
For the period 3.
What will he do with the payslip? No grocery shop is going to give him goods on that.
It's for the department now.
That we will see.
Lord, one correction. It's not March, it's February 2020.
February 20.
What all like?
Interlocutory application, sir.
I'm grateful, man.
Yeah. 227 ಮಾಡಿ I would be able to get tomorrow. Mr. Ahmed went away. Yeah, but I told you, no? Okay. Heard Mr. M. Ahmed, Learned Counsel for the petition. Also heard Mr. B. Kaushik, Learned Standing Counsel, Elementary Education, Department of School Education. The petitioners, by way of instituting the present writ petition, has prayed for a direction upon the respondent authorities to release to them their areas, the areas of their salary pending with effect from March 2012, as well as for a direction for release of the current salaries of the petitioner. Also, as projected in the writ petition, the petitioners were appointed as assistant teacher, as stipendary teachers by the District Elementary Education Officer, Sipsagar, and the Deputy Inspector of Schools, Nazira and Soraidev subdivisions during the years 1994, 95, 1996, and 1999. The appointment of the petitioners as stipendary teachers is projected to be so done after a due selection was carried out in the matter. The petitioners categorically submit that they are not irregular and or illegal teachers and had been recruited after they had applied, after they were selected in a selection held in pursuance to an advertisement issued for the purpose. The petitioners project that after the completion, project that they were deputed to undergo the basic training course, and on completion of the said course, the petitioners were authorized their respective scales of pay. Also, the petitioners contend that they were in receipt of their regular salaries till August 2006. However, post August 2006, the payment of their regular salaries was stopped, and the names of the petitioners came to be included in a list of excess teachers. The salaries of the petitioners were being thereafter released on annual retention basis. The petitioners project that in the year 2009, their names were so incorporated against supernumerary post created for the purpose of releasing to the petitioners their due monthly salaries. As projected in the writ petition, around 1528 numbers of supernumerary posts were created in the year 2009, and the petitioners contend that they are and such posts was created for them also. The petitioners in the above noted writ petitions were in the above manner being released their salaries till February 2012. The petitioners have also projected that they being in continuous service after they being appointed after a due process of selection and being in continuous service, having completed their respective basic training courses, the petitioners are at par with regular employees, and accordingly, their salaries in arrears with effect from March 2012 till the March 2012 was to be released to them. The petitioners, in support of their case, has placed reliance, had referred to the directions passed by a coordinate bench of this court wide order dated 8/8/2016 in WPC number 3045/2012, which is projected to have been instituted by persons similarly situated like the petitioners herein. So the salaries of the petitioners having remained in arrears in spite of repeated approaches made by the petitioners, the petitioners have instituted the above noted writ petition, praying for the reliefs as noticed herein above. Mr. M. Ahmed, learned counsel for the petitioner, at the outset has submitted that the case of the petitioners herein is squarely covered by the decision of a coordinate bench of this court passed by order dated 8/8/2016 in WPC number 3045/2012, and accordingly, the petitioners in the above noted writ petitions are also entitled for a direction to be authorized their respective salaries since March 2012. Mr. Ahmed has submitted that the petitioners in the present writ petitions were all recruited in pursuance to a process of selection and were appointed against regular sanctioned vacant posts. Accordingly, he, however, submits that the respondents in the education department, with a view to provide protection to otherwise illegally and irregularly appointed teachers, had denoted the petitioners to be excess appointees, and accordingly incorporated their name in a list of 1528,
1574.
1574
and 960.
1528, a list of illegal teachers, and had created supernumerary posts for payment of salaries to them. Mr. Ahmed submits that the petitioners herein being recruited in pursuance to a regular selection process, initially as a secondary teacher and thereafter on completion of their basic training course as an assistant teacher, the authorization of the scale of pay of the petitioners on completion of their respective basic training course would go to indicate that the petitioners herein, petitioners in the above noted writ petitions, were all recruited by following the due process mandated in this connection. Having made the said submissions, Mr. Ahmed has referred to a process initiated to order issued to the petitioners in the above petitioners to some of the petitioners in the above noted writ petitions, engaging them as teachers oblique tutors with prospective effect, that is with effect from 1/11/2020, and also bringing them within the purview of the new pension scheme. Mr. Ahmed submits that the said accommodation made in respect of the petitioners, comma, involved in the above noted writ petitions would be of no consequence inasmuch as the same has the effect of wiping out the services rendered by each of the petitioners with effect from the date of their respective initial appointment. He submits that the petitioners having been appointed as assistant teachers in continuance of their initial appointment as a stipendary teacher after completing the basic training course, comma, the date the petitioners are required to be deemed to be in a regular service with effect from their respective dates of appointment as a stipendary teacher. Mr. Ahmed has submitted that the subsequent accommodation of the petitioners as teachers of like tutors was so made, taking advantage of the position the petitioners had found themselves in to be on account of non-receipt of salaries since May 2012. Since 2012, they are not receiving March 2012. Mr. Ahmed submits that the said accommodation would also not be maintainable, considering the bargaining power the petitioner had with the mighty state. In this connection, he has referred to the decisions of the Honorable Supreme Court in the case of Central Inland Water Transport Corporation Limited and another versus Brojonath Ganguly and another, reported in 1986 3 SSC 156, and the decision of the Honorable Supreme Court. It relies on the following decisions of the Honorable Supreme Court. 1, 2, Union of India and others versus Bharat Enterprises, reported in 2023 SSC Online SC 369. So, in the above premises, Mr. Ahmed submits that although the petitioners have not assailed the subsequent accommodation orders passed in their respective cases, in the present petition, this court would be pleased to modify the relief sought for in the petition and direct the respondents to effect such accommodation with retrospective effect, that is with effect from 1/3/2012, and to release to the petitioners their salaries for the said period. Mr. Ahmed further submits that as some of the petitioners have already retired and or died in harness, the respondent authorities be also directed to reckon the period of service rendered by the petitioners with effect from their initial engagement as stipendary teachers for the purpose of computing their pension and pensionary benefits, which is now required to be so computed by applying the provisions of the Assam Services Bracket Pension Rules 1969. Per contra, Mr. B. Kaushik, Learned Counsel for the petition for the Learned Standing Counsel, Department of School Education, appearing for the state respondents, has submitted that In pursuance to directions passed by this court, with regard to the manner in which the services of illegal and irregular teachers are to be so considered, the government had placed the matter before the cabinet in its meeting held on 26/2/2011. Thereafter, in terms of the decisions arrived at in the matter, the Education Department had proposed to constitute a screening committee to examine the validity of the appointments of teachers who are claiming regularization and salaries. Accordingly, an office memorandum dated 15/11/2011 was issued and a screening committee was constituted to examine the cases of irregularly or illegally appointed teachers so as to arrive at a decision for their regularization and entitlement of salary or otherwise. Also, to facilitate the teachers who are not in receipt of salaries for considerable periods of time and who have been projected to be either irregularly and or illegally appointed, to have their cases considered by the said screening committee constituted by the office memorandum dated 15/11/2011, the director of elementary education Assam had published advertisements in newspapers inviting applications from such category of teachers appointed during the years 1991-2001. Such advertisements were issued in the news dailies in its issues dated 1/2/2012 and 4/2/2012. Mr. Kaushik submits that in pursuance to the said advertisement, along with other similarly situated persons, the petitioners had also submitted their respective application along with the requisite particulars for having their cases placed before the screening committee. Mr. Kaushik commits that the present writ petitions, the above noted writ petitions were only instituted in the year 2017. However, in the writ petitions, the petitioners have not challenged the process initiated by the advertisements, said advertisements dated 1/2/2012 and 4/2/2012. Mr. Kaushik has further submitted that the petitioners in the above noted writ petitions have also not projected as to why the process as initiated, why the advertisement dated 1/2/2012 and 4/2/2012 cannot be made applicable in their respective cases. Also, Mr. Kaushik submits that after the applications were scrutinized and the persons eligible for being placed before the screening committee shortlisted, the constituted screening committees had proceeded to examine the applications submitted in the matter. And thereafter, the the screening committees as constituted had segregated the candidates, teachers appearing before it, into 4 categories. So, as the broad categories into which the petitioners were so applicants were so incorporated are as follows. Page 249. A number kita jikita dia ase নহয় ekhini nidibi. Category 1, recommended and working till. So, Mr. submits that on conclusion of the follow-up proceeding involved, comma, follow-up proceedings involved, and also on a receipt of the approval. The committee constituted for the purpose had prepared 3 lists. List 1 included teachers who received salaries at some point of time and had JBT/DEL.ED qualification. List 2 included teachers who received salaries at some point of time but did not have JBT/DEL.ED qualification. And list 3 involved teachers who neither received salaries nor qualified the training in JBT/DEL.ED qualification. Basing on the cabinet approval granted in the matter, persons included in list 1, petitioners in the above noted petition who were included in list 1 came to be accommodated as teachers against posts created for the purpose personal to them. The petitioners in the above noted petition who were included in list 2 came to be so accommodated against posts of tutors as created for them, as created personal for them. The petitioners in the above noted petitions who were not included in either list 1 or list 2, were not extended with accommodations of their services against as teachers and or teachers. Accordingly, Mr. Kaushik submits that the petitioner's participation in the process initiated by the advertisements dated
1/2/2012 and 4/2.
One to 2012 and 4/2/2012 admittedly reflects that the petitioners were the initial appointments of the petitioners were either illegal and or irregular. Accordingly, he submits that the period of service rendered by the petitioners, that for the period of service rendered by the petitioner after March 2012 till the accommodation made in respect of the teachers who were included either in list 1 and list 2 indicated herein above would not mandate a consideration by this court. I've heard the learned counsel for the parties and peruse the materials available on the court. Heard the learned counsel at some length. Hearing remains inconclusive. Registry to list this matter again on Tuesday. On Tuesday. I'll move it. I finished this much. Next day we'll finish the rest.
That those accommodation orders, appointment orders contain the condition, my lord.
That will, I'll get it. That I'll get it. I passed similar orders
Yes,
in
yes.
the, that's why I did not. Sipsagar, rotation. Those were the days. A good time for the lawyers. Fine, here we go. If there are any interim orders to be extended, kindly inform the court master. Any dates you want, inform her. She'll give you.
There was one item, item 50. This is a disciplinary action. Disciplinary punishment was given, my lord. The records were summoned by your lordship on 29th of April. The records are here, my lord. He is retiring next year, my lord.
Next year?
Next year, my lord.
After vacations.
I think.
Is there a partnered matter before this court?
Not a partnered matter, my lord. Lordship has summoned the records.
We have done 3-4 departmental proceedings today. I think that's enough.
Item
You get a date whenever convenient to you. After the vacations, we'll say. You have got the records.
My lord.
Yes.
You have got it. What is the issue?
My lord, the issue is, my lord, he was serving as the principal of Assam Engineering College, my lord. You know, during that time, my lord,
51, listen, pause list to
29th of April, your lordship has passed that order. So, my lord, 8-year-old allegations, my lord, suddenly crops up, my lord, and DP is initiated against him. He was suspended also, my lord.
51.
50. 50.
Yes.
I'm only requesting, my lord, because lordship has directed that records should be summoned. Pleadings are complete, my lord. It is possible, my lord.
It is committed, the pleadings in the matter is completed and the records have been, records of the department proceeding instituted against the petitioner in original has been received. So, accordingly, registry is directed to list this matter again. When? When is it convenient?
Possible, my lord, next week, my lord. It's a short matter, my lord. I will. So, my lord, any date convenient to your lordship?
Not convenient. May you give me a date other than before 27th? Any date after 27th?
So immediately after reopening.
On 16 তারিখে আছে নাকি ভোট? 14 তারিখেও আছে না? 21. On 21/7/2026. The records received by Mr. S. Das be retained and produced before the court on the next date of listing.
Item 48, my lord. Small issue, my lord, regarding appointment of in charge.
Your small issues, I know.
Can it be taken about 19, my lord?
What is the small issue?
What happened, my lord, on the basis of a public complaint, my lord, petitioner is not appointed as in charge principal. Instead, my lord, the IAS has been appointed. Possible has heard the matter, my lord. My lord, the direction was given to the standing council, my lord, to produce the complaint, my lord. That is also dear, my lord.
What is the nature of the complaint against you?
The nature of the complaint is that, my lord, some private person made a complaint that some SMSs were exchanged with the petitioner and his wife.
Huh?
And his wife. SMSs were exchanged from the petitioner and with his wife, my lord, from private person. He made a complaint in the school.
The
On the basis of
petitioner
that-
and his wife exchanged SMS message.
My lord.
What happened then?
On the basis of that, my lord, my lord, the managing committee of the school, my lord, that do not.
What
want
is the
petitioner-
nature of that messages?
No, my lord, no
Huh?
other messages, my lord.
Okay.
I have seen the messages also, my lord.
It got leaked.
My lord.
You're a headmaster, aspirant. Huh? If you don't know how to control your mobile,
There is no, my lord, allegation of sexual harassment inside the campus, my lord, or my lord, no complaint has been lodged by the husband also, my lord, before the police. Only on the basis of that, my lord, he cannot be restrained. On
23 তারিখে did you? 23.
But in respect of item number 38, Lordship may not take up this matter.
I
Lordship.
cannot.
Yes, Lordship. We saw earlier round of litigation, Lordship appeared for.
What is the issue?
Lordship, regarding termination of
Did not
service.
read the-
Termination of service, Lordship.
Oh.
He has, on the basis of the DTO report, Lordship, he was terminated because 4 years requirement of.
It is submitted the they list this matter before any other bench without me.
38.
38.
So, but I did not, for my lord, any date, my lord,
Huh?
34, my lord.
She'll give you. She'll give all the dates. She'll give.
My pleasure.
If she does not give, tell me.
My lord. My pleasure, Lordship.
Huh?
Item 43 is the medical report is received in seal pack. This matter
What
related to
medical
CRPF.
report? What medical report?
This matter related to CRPF.
Hmm.
According to the last order, they are send them to GMCA for performing their TM performance.
Ear problem.
Yeah, problem is Lordship.
Two different reports. So Lordship directed the principal GMCH to construct a medical board and furnish the report in a seal cover through me.
Who is for the government? Bihu gift. We have Christmas gift, Bihu gift, New Year gift. This will be summer vacation gift for him. Date ta dia. Mongal Budbar mane dia. 17. Mr. It will see wait.
Record.
You take it?
No,
Feel
Lordship.
it? Huh?
Lordship, otherwise it can be kept as a part of the record, Lordship.
Mr. We keep it as a part of the Mr. Kumar. Mr. D. Upaman, learned counsel for the petitioner, in terms of the directions passed by the court, had produced the report submitted in the matter by the medical board constituted in the Gauhati Medical College Hospital. Also, in a seal cover. This court has, on opening of the seal cover, perused the report. This court directs that the report submitted by the furnished by the medical board, wide the forwarding dated 3/6/2026, be kept on record. It recorded. Be kept on record and marked as X for the purpose of identification. Registry to list this matter again on 17/6/2026. You make a mention in the morning and you get the government advocate. Thank you, Mr. Governor.
Obliged.
I look my Twitter. Like summer vacation gift.